आता एकदा चेक करा सर आवाज युट्यूबला.
गिरी सर येत नाही ना
स्क्रीन आली बर का.
आवाज फक्त आता तुम्ही बोलताय तो येतो का चेक करा फक्त.
नाही येत नाही येत. येस येस
आलाय. आता एकदा
आला.
चेक करा सर आवाज युट्यूबला.
येस येस आला आला.
करा त्र्यंबके मॅडम तुम्ही.
ओके ओके थँक्यू मॅम. स्वागतम सुस्वागतम शुभ स्वागतम. स्वागतम सुस्वागतम शुभ स्वागतम. पुणे जिल्हा शिक्षण मंडळाच्या बाबुरावजी घोलप महाविद्यालयात वाणिज्य विभागानं तृतीय वर्ष वर्गातील विद्यार्थ्यांसाठी आयोजित केलेल्या इंटेलेक्च्युअल प्रॉपर्टी राईट्स लॉ या शॉर्ट टर्म कोर्समध्ये मी या ठिकाणी उपस्थित असणारे मान्यवर, आजचे व्याख्याते आणि सर्व विद्यार्थी मित्रांचे सहर्ष स्वागत करते. विद्यार्थी मित्रांनो, आपण 11 तारखेपासून या ठिकाणी या शॉर्ट टर्म कोर्सला सुरुवात केलेली आहे. या कोर्समध्ये आपल्याला इंटेलेक्च्युअल प्रॉपर्टी राईट्स त्याच्या संबंधित असणारे कायदे याविषयी माहिती या ठिकाणी देण्यात येत आहे. आज आपल्या या वर्कशॉपचा शॉर्ट टर्म कोर्सचा 4था दिवस आहे. आज या 4थ्या दिवसामध्ये आपल्या सर्व विद्यार्थ्यांचं मी या ठिकाणी स्वागत करते आणि आपले आजचे जे व्याख्याते आहेत त्यांचं या ठिकाणी मी थोडक्यात परिचय करून देते. आपले आजचे व्याख्याते आहेत आदरणीय राजेंद्र गवते सर. या राजेंद्र सरांनी ग्रॅज्युएशन त्यांचं BSc कॉम्प्युटर सायन्स या विषयामध्ये कंप्लीट केलेलं असून त्यांनी पोस्ट ग्रॅज्युएशन MBA मध्ये केलेलं आहे. यांना एकूण 7 वर्षाचा एक्सपिरियन्स असून सध्या ते इन्फोसिस या कंपनीमध्ये सिनियर मॅनेजर या पोस्टवर या ठिकाणी कार्यरत आहे. राजेंद्र सरांनी लर्निंग अँड डेव्हलपमेंट या ठिकाणी अशा प्रकारचे प्रोग्राम ते त्यांच्या इन्फोसिस कंपनीमध्ये एम्प्लॉईसाठी या ठिकाणी राबवत असतात. तसेच या ठिकाणी या सरांनी स्वतःचे असे 2 पेटेंट्स या ठिकाणी त्यांचे स्वतःचे 2 पेटेंट्स आहेत की म्हणजे 2 संशोधन करून त्यांनी स्वतःचे पेटेंट्स या ठिकाणी तयार केलेलं आहे. अशा या बहुगुण संपन्न व्याख्यात्यांचं या ठिकाणी मी स्वागत करते आणि राजेंद्र सरांना विनंती करते की त्यांनी या ठिकाणी आपलं आजचं जे व्याख्यान आहे या ठिकाणी या व्याख्यानास सुरुवात करावी.
Okay, thank you so much, ma'am. Thanks for introducing myself. Okay, so hello guys, good afternoon again. And then yesterday we have gone through the Indian Patent Act 1970. So today we'll just have a look. Okay, we'll have a read and we'll get with the one video which is more related to how you can file your patent form, and then we'll continue with the next topic, which is a copyright. So basically, yesterday we have seen what is intellectual property and then what is intellectual property rights, why it is required. Then the Indian Patent Act we have seen. Okay, so the Indian Patent Act 1970 and the rule is 1972 that we are currently using. The history we have gone through yesterday. What is the Patent Law 1856, and then what is the Patent Design Act 1911, and then the Patent Act 1970 and Rule 1970, and currently what we are using is the Patent Act 1970, but the amendment is 3rd, and which is started from the 2005. Then we gone through the what is patent. Okay, purpose of getting a patent, why patent is required, then what can be patented. So it should be any innovation or invention that you are doing, it should be passed through that 4 basically test. Okay, so it just pass this 4 test and then you can call it as a patent. Okay, or innovation. Then what are the different salient features of your patent law, that also we have seen. What is the term of patent? So almost like every patent has 5 to 7 years, and then you can maximally extend it to 20 years. Okay, after paying a renewable fees every time. Then what are the safeguards of the patent law, that also we have gone through. Then what types of patents are there? Okay, so like the 3 main basic types of the patent. One is an ordinary patent, a patent of additions, a patent of conditions. Also we have gone through the patent types. Okay, according to the classification, the one is a product patent and another is the process patent. Then what is exactly the patentable innovations? Okay, and what is the definition of new according to the patent law that we have seen. Also we have gone through the inventive steps. What is mean by inventive steps, and what is the industrial application means according to the patent law. Then we Okay. Then the non-patentable inventions. Okay, what is exactly the non-patentable invention? So, and that comes under the Atomic Energy Act 1962 is called as a non-patentable invention. Then the term of patent. Okay, so how many years? It like as already said, 5 to 7 years, and in case of the 14 years of the invention, then expiry of the patent, in what circumstances your patent get expired, that also we have seen yesterday. So then we have gone through the stages from filing to the grant of a patent. How can you go ahead? Okay, so what is the right way to obtain a patent? Okay, what are the different methods to obtain a patent, and how can we fill the form, that we have also seen. So the one is like the information that is you want about your patent is mainly available on the website, the government website, which is www.ipindia.nic.in. Okay, so whenever you want any more information about patent filing, about patent, what can be patent, what cannot be patent, everything you will get in this below websites. Okay, so whenever you get some free time, just roam around it, just hog the website and just look for all the things that you can. Then we have gone through the formality check. Okay, what are the prerequisite, what is the eligibility criteria, what could be the patent, what could not be the patent, everything that we have seen yesterday. Then moving ahead with the next thing, okay, that is about the publication. After filing the patent, after the 18-month everything, the patent would going to be showcased in the government journal. Okay, so which is basically it's your innovation is in published in front of the people or in front of government or public. Then the request for examination. So if you're thinking that you're not capable, whether your patent is accepted or not, so you can ask for an examination. Okay, then after the examination, it gone through the examiner, and then examiner will give you the FER. FER is nothing but your first examination report. It gone to go through the controller, and control comes up with his own thought or in any objections. If there is any objection, you have to fulfill that objection within a 12 months, and then you got the patent at the end. Okay, so we have gone through the stages as well. How can we feel a patent? So one is you can feel the application, whether it is a provisional or complete application, then publication of application, then request for examination, then examination issue for FER. FER is nothing but again it's the first examination report given by the examiner. Then it should be going ahead with the grant patent. If after granting a patent, is there any opposition? So you have to fulfill that all oppositions and within a 12 months, and then decision of a controller again, and then it's appellant board. And if there is might be amendment, so it could be amendment or it could be a revocation. And then about the renewal fees, okay, according to the patent, it should be the renewal fee again. And then right of patentee, okay, the one who is filing the patent is called as a patentee, or one who is holding the patent called as a patentee. So these are the couple of rights of patentee. Okay, so today we are going to see about how can you file a patent in India. So basically this video will let you know that how you can file your patent. Okay, file your patent form, application form. So I think everyone should go ahead with this, because this is very, very important to understand.
Hello everyone, welcome to our second series on how to file patent by yourself in India. See, if you are an innovator, a product designer or researcher and you love to make new things, innovate, believe me, please protect it. Do not give it away for free. Your ideas, innovations has great value, and it is only possible with the help of patenting, with the help of the provision of patenting. Okay, so apply for a patent before disclosing it. In our previous lecture, we learned regarding patent specifications, where we discussed regarding provisional specification and complete specification. So while you're submitting the draft, whether it is provisional or complete, it is required to submit few forms which accompany along with your draft, and in that form 1 is mandatory, because at the time of filing it is required to submit or mention the applicant, the innovator, right? It is required to submit your name, right? That is possible with the help of Form 1. It is a 4-page document, and today we are going to learn each parameter in Form 1. So first is applicant's reference identification number. See, if it is your first time filing, leave it blank. You are not required to mention anything. But suppose you have already submitted a provisional application and you have a patent application number. At the time of complete specification submission within 12 months tenure, you are required to mention the patent application number there. Okay, only if you have filed provisional, you have a number, then at the time of complete specification, you have to mention up there. Otherwise, leave it blank. The next parameter is type of application. Here, select ordinary. If you're filing it in India, select ordinary. There are other parameters like conventional and PCT. At present, you do not need to know regarding the same. And if you're interested to write us in our comment section, we'll drop your mail for the same. Okay. Next is applicant. This is very important because applicant is the owner of the patent. Applicant means the person who will have the complete right, authority to sell the patent, make modification into it. The signatory of your idea is the patent applicant. So here you need to mention your name, address, country, nationality very carefully without any error. See, there can be multiple applicants also. And here, even an entity can be an applicant. Let's see the next category, which is the category of applicant. Here, it can be a natural person or other than natural person. Now, let me explain. Suppose you are filing your own patent. You are a human being, so you will be considered under natural person. Now, suppose a company is filing a patent, then it will come under other than natural person. Other than natural person is again subdivided into small entity and others. Small entity means the company which falls under micro, small or medium scale industries. And the company which are considered as a large entity, which is apart from small, medium or micro, is considered as others. So suppose a company wants to file a patent, it will fall under other than natural person and it will include its name as an applicant. Okay. Even natural person can be a joint applicant along with an entity. It is also possible. Okay. Next session is innovator, that is inventor. An inventor can only be a natural person. Now let's understand here. The question is, are all the inventors same as applicant? Now suppose you are filing a patent and you are the person who have innovated something and you are applying for a patent. So you will be the innovator and you will be the applicant. So here enable yes in that case. Now suppose there is a pharmaceutical company. It has hired few people to invent or innovate a new medicine. In that circumstances, all the people who have worked to manufacture or to create that medicine will be considered as innovators. But who will be the owner of the medicine? It will be the pharmaceutical company who has funded the entire project, who is providing salary to those people to create an innovation. In that circumstances, the company will serve as an applicant and the innovators, the people who are working will be innovators. In that circumstances, you will enable no here. Okay, in case an entity is filing, you will enable no here. And suppose in case no is enabled, you have to mention each and every innovator's name under this title. There can be multiple innovators, like in case there can be multiple applicants also. The next category is title of the invention. We have discussed regarding title when we were discussing regarding specifications in provisional and complete. The title which you have adapted for your patent application needs to be written here. As discussed before, just for a revision, the title can only be of 15 words and it should explain the entire patent. within those 15 words, right? So it needs to be mentioned here. The next is, if biological material is used in the invention, suppose you have worked on a living organism, anything biological in that circumstances, or no. Suppose you are working on an engineering field, enable no because no biological material is being used. Otherwise, enable yes if any biological material or any mutations you have worked on. Okay. Next is authorized registered patent agent. See, if you are filing, because we are learning here self-filing, you need to write any, not applicable. Because in case there is an agent involved, there is an authorized patent agent involved, he or she needs to mention the patent agent number here. In your case, you can just discard it by scratching it off. Okay. Next is address of service of the applicant. Here, you need to mention the communication address. That is, all the communication with the registry wants to do with you. That address needs to be mentioned here. Suppose there are multiple applicants. In your case, you can mention one applicant's address, phone number, and email ID on which the government can send the documents, communicate with you, and update you regarding the patent proceedings. Okay. Next is declaration. First is declaration by the inventor. This paragraph almost works like a power of authority. Here, all the innovators need to sign and declare that this invention which we are submitting, we authorize this person, that is the applicant, to sign on our behalf. We are handing all the invention done by us to this applicant. It is a declaration, almost works as a power of authority. So all the innovators whose name has been mentioned in the document before needs to provide their signature here. Okay, so because of that, you do not have to submit an additional power of authority in this circumstances. Okay, the next is declaration by the applicant. Here, there are few declarations that the applicant makes to the registry at the time of submission. So we will see one by one. The first is, we are in possession of the above mentioned invention. Here the applicant accepts that the idea which we are applying patent on is our invention and we own it, we have it. We are not copying or claiming anybody else's patent. So that is what is declared in the first statement. The second statement states that the provisional complete specification relating to the invention is filed with this application. Here, in case you're submitting a provisional patent, then you need to scratch the word complete. In other case, if you're submitting a complete, you need to scratch the word provisional. Here, which states that along with this form 1, I'm submitting either my provisional or my complete application. Okay. So that is stated in the second statement here. Next is, this invention as disclosed in the specification uses the biological material from India. So here, in case you are using any biological material, it needs to be declared here. If you are not using any biological material, you can scratch this line. It is not required for you. Okay. The next is, there is no lawful ground of objection to the grant of the patent. See, as an applicant, you need to declare that I think this is a very novel design and this is very innovative and I think there is no chances of any objection. I accept that I have worked hard to make this idea patentable, so you need to grant it to me. That is what the statement declares here. The next statement states is, we are the true and first innovator and there is no lawful objection to the grant. Here, the applicant is making a declaration on behalf of the inventor. They are stating it that we are the first and true innovators and nobody else has done any innovation like this. So that is why it is novel. And I don't think there is any reason for any objection and you need to grant us this. It is a declaration and it is mandatory to make. So you just need to enable it. Do not ask too many questions. It is a statement which needs to be accepted. Okay. The next is, we are the assignee or the legal representative of first and true innovators. That means the applicant accepts here that I have been given the permission by the innovator to be the legal assignee, and I'll be doing all the needful regarding the patent procedure. That statement is declared here. Okay, so I hope all the declaration by the applicant is very clear, and which needs to be enabled. Read it thoroughly and then enable it. Okay. Next, here, what are the attachments that are going to follow along with Form 1 needs to be stated here. Form 2, see, we'll be discussing about Form 2 in our third lecture, so do subscribe and keep watching. The next is description included. What are the draft that you have submitted includes? Whether it is a complete specification or a provisional specification, it needs to be submitted here. The number of pages, how many pages are they? Okay. Next is, if it is a complete specification, the number of claims, the number of pages which have been included in the claim. Abstract, how many number of pages is your abstract? And if there is any drawings attached, how many number of drawings are there? Means pages are there. It needs to be submitted here. Okay. If there is any additional document like power of attorney or power of authority, it needs to be, added here in this section. Okay. Next is, see, if you're doing a physical filing, you need to submit a check or a draft for the government fees, right? So if you're submitting a check or draft, here you need to mention the total fees that is being submitted, the check number, the bank details, and the date on the check needs to be submitted here. Okay, I don't think there is much to explain here. Just the demand draft details or the check details needs to be submitted here. This is an acknowledgement, like a declaration by the applicant, which states that I or we hereby declare to the best of our knowledge that the information and belief and the fact matters stated here are correct. It is a declaration that all the details which I have provided above are correct, and I have not tried to create any confusion or ambiguity, and I accept. And we request that a patent may be granted to me or us for the said invention. It is declared here. Okay. Next, last parameter on this page is dated this. Means the date on which you're submitting the Form 1 needs to be mentioned here. Okay, and last is signature and name of the signatory. See, if there are multiple applicants, everyone needs to sign here. If suppose you're providing power of authority that from all the applicants, one person is going to be the signatory, you need to mention only that person's name, and that person need to sign every page, or in the case of this patent filing, all the places where the applicant needs to sign needs to be signed by that person only. And to the controller, you need to mention the jurisdiction. So what are the points that needs to be remembered? It needs to be submitted with provisional application and also with complete application. See, Form 1 needs to be filed at the time of provisional and also at the time of complete. And if you're directly submitting a complete, obviously you need to submit a Form 1. Okay. Applicant is the owner of the patent. So you need to be very careful that suppose you are like the innovator and you are the applicant too. Now you have called few friends to work with you. Be careful, do not add everyone's name into applicant, because all the applicant has equal right on that idea. So if there is a, you sell it, you commercialize it, every person who is an applicant will have equal rights on your idea. So be careful whose name you are including as an applicant. Okay. Only a natural person can be innovator. See, in case of applicant, an entity can also be an applicant. But in case of innovator, see, only a person can innovate, right? So only a natural person can be included as natural person. As an innovator. And there can be multiple innovators if you want. The details submitted at the time of provisional should be the same in case of complete specification. That means when you're submitting Form 1 at the time of provisional, the data should not change. You cannot add or subtract the applicant, the name, the address in case of applicant or innovator. The data should be exact or your application gets rejected. Okay, so be careful when you're submitting the data. even the title which has been submitted at the time of provisional or in your drafted document should be same in case of Form 1 when you're submitting in the case of complete application. Do not change these data. Okay. So I hope you're quite clear what are the details that needs to be submitted in the time of filing of Form 1, when it needs to be submitted. See, if you have any query after this.
Okay, so yep, we had just gone through the video, and like it has clearly mentioned a couple of things, okay, that we have to take care while filing the application form. Okay, so basically we do file the provisional as well as the completion form. The provisional one when you are registering something, okay, when you have something in your mind but you have not completed it, in that case, in that scenario, you can go ahead with the provisional form. And the second, once you complete that activity, complete that task or innovation, in that case you can move ahead and file the complete application form. So this is all about the Indian Patent Act 1970. Okay, so if you do have any questions, anything, that you can like reach out to your college, and then your college teachers will reach out to me for all the queries that you have. So today we are going to see the second thing, and the second thing about the intellectual property rights, which is the copyright. Okay, so let me present it. Okay, so the content basically that what we are going to say in this. So one thing is like definition and scope of copyright, and then the Indian Copyright Act and its perspective, why it is required, then assignment of copyright, then infringement of copyright, then remedies for infringement, and then limitations to copyright. Okay, so these are the content that we're going to see in today's class or in today's session. So let's start with the first thing, what is copyright? Okay, so I hope you all have seen this C mark, okay, in the circle C in the various books. Okay, whenever you can buy any original book, okay, you will see that C is always there. It is nothing but a copyright. Okay, this is a symbol for the copyright. Okay, so basically whenever C is there, there is always one line mentioned behind the below to that symbol called as a copyright, all rights reserved. Okay, let's talk about this word more. Okay, copyright. Okay, so copyright is a, let's change it. Okay, just break the word copy and write. Okay, write, not to copy. Okay, if I want to say, I would easily say in a nutshell, write, not to copy. Okay, if something I am creating, okay, whether it is a music, whether it is a literary, whether it is a design, whether it is a software, okay, if I'm creating something which is absolutely new, okay, no one has created yet, that I can say that that is my right, okay, to reserve it, and I cannot give anyone that the one can who copy. Okay, so most of the time we see that, like whenever new movie releases on the in the theater, basically they try to avoid people not to shoot that movie, also not to place that movie in a public domain websites. Okay, so because they have a right of that movie and they want to earn money out of it. Okay, so specifically copyrights is called as the all rights reserved or right not to copy something which is created by someone. Okay, so according to the Oxford English Dictionary, what is the meaning or what is the definition of copyright? So basically the exclusive right given by law for a certain term of years to an author, composer in the sense the music composer, the who is composing music, etc., or his assignee, to print, publish, and sell copies of his original work. Okay, let's read it again. The exclusive right given by law for a certain term of years to an author. Okay, so it is an exclusive right, okay, specific right given to the author or composer or his assignee, okay, someone who is working with him. Okay, so sometimes there is no one music composer, there are a couple of composers working together. Okay, so they are getting right, okay, to print, publish, and sell copies of his original work, okay, at least for a couple of years. Okay, so that is it, nothing but your copyright. Okay, so in the simple word we can say that copyright is a type of intellectual property that protects original work of authorship as soon as an author fixes that the work is a tangible form of expression. If somebody is coming with the new song, that song against that particular composer. If somebody is writing a new book, okay, the once he written the book and published it, okay, the book is again the author. Okay, so once you're able to see something or able to hear something that is a tangible thing, then you can call it as a copyright. Okay, so in copyright law specifically, there are a lot of different types of works, including paintings. The one who make the paintings are there, photographs, illustrations, musical compositions, sound recordings, computer programs, books, poems, blog posts, movies, architectural work, plays, and so much more. Okay, so specifically when we are talking about copyright, so copyright covers the below things. One is the painting, it covers the photographs, it covers the illustrations, it covers the musical compositions, sound recordings, then your computer programs, your books, your poems, your blog posts, your movies, your architectural works, plays, and so much more. So this is all about a copyright. Okay, so basically the copyright is protecting the originality of that particular product. Okay, so specifically it is a protecting the original thing about that particular product, which is nothing but is your copyright. Okay, so if you have a song, okay, which is like you cannot play that song in a public place without asking for that right. Okay, or if you want to show your like any movie, okay, we see a couple of movies are coming later on the OTT platform earlier than it's they are coming in your theater. Okay, so whenever someone want to place that movie into their website or into their OTT platform, in that case they have to ask the copyright for the director of the film. Okay, so until and unless they cannot ask the director and director has not permitted to show their movie in their website, till the time they cannot show, if they need to suffer a losses, huge losses. Okay, and also some specific legal problems. Okay, so specifically whenever I want to show something which is created by someone else, I have to take that right. That is nothing but a copyright. Okay, and the person who is holding all the rights called as a copyright. Okay, suppose if you can take an example of any particular book. Okay, you cannot, once the book is written, the author is writing his name at the end saying that the book is written by Chetan Bhagat, suppose, or any author, the big author. Okay, so I have to sell that book using his name, but before selling or before printing the new edition, I need to go ahead and ask the person, okay, can I publish? Shall I publish? Okay, how much percentage you will get after every selling of every single book? Okay, or like how much lump sum amount you are taking? Okay, that is what. Also, like someone is singing a nice song, okay, like Lata Mangeshkar or someone else. If someone is singing a nice song, then in that songs, okay, she is asking for some amount. Okay, so the people can use the same song, okay, for their own purpose. Okay, so that is a what is a copyright, it's all about. So what can be protected? Okay, so whenever we are talking about copyright, so what are the things that can be protected, okay, against the Copyright Act? So very first thing, we can protect literary or dramatic work. Okay, literary is, it is nothing but a literature. Okay, the moreover your poems, your books, your subject books, your novels, anything that can be written by the human. Okay, or any dramatic work. Okay, so like writing a drama, movie, anything that could be protected, again protected by Copyright Act. Then second thing, a musical work, anything that you created your new tone, you created your new song, okay, you created your music to the any particular film, background noise, okay, background music, you created any particular tone, new tone. Okay, so all things get protected by your Copyright Act. Third thing, an artistic work. Okay, so anyone, like any artist, okay, there are a couple of artists, like someone is a good guitarist, so if like he's coming with a new tone, that is also the thing. Okay, if someone is like a good like playing a good actor, okay, if he can be save his dialogues, okay, so that can be also protected. Okay, then a cinematograph film. Okay, so any film, like specifically you are like doing any particular shooting at some places, okay, and you think that you the only one who has found that place, and then you're working on that place. So that place also, that film also, that scenes also, that I would say the stage and the everything that you can copyright. Okay, the a sound recording. Okay, so whatever the sound you're recording for anything, any purpose. Okay, if like you think that sound is made by you, okay, there is no previous connections, okay, no one has made it before, in that scenario you can go ahead and protect that. Then a photograph. Okay, if you think you have taken any particular photograph which no one has taken yet, or someone is still looking for, okay, and the photo has not been taken yet, so that photo also you can use as a that photo as a copyright. Okay, so we have seen that example, right? Every time we are able to see that small hills and then small river outside and then the windows. Okay, whenever like we open the window, we see the same kind of picture every time. Okay, that is also a copyright picture. Okay, taken by someone. Okay, so that picture also you can copyright. Okay, if like window want to use that picture for their any application or anything, that in that case they have to pay some royalty or anything, that the amount that to be that particular person. Okay, that is a photograph. Then a computer generated work, anything that like any software, any application, okay, that you did, okay, any particular program that you made, okay, using the computer, is that should be also protected. Okay, so specifically whenever we are talking about what can be protected, so these are the things. Okay, these are the list. Okay, so below listed things, or like showing the listed showing things, can be protected by the Copyright Act. Okay, so whose rights are protected? So the next slide is about, we have seen, okay, so what can be protected. Now we'll be going to see whose rights are protected. Okay, so the copyright protects the right of author, that is creator of intellectual properties. Okay, so copyrights protects the right of author. Okay, that is a create an intellectual property, right? Suppose being an author, okay, author has to do a lot of things, right? Author has to think a lot, he has to read a lot, he has to write a lot. Okay, after doing all these things, okay, he able to write a book, right? So that is absolutely the intellectual, because he is using his intellectual. It is not like that someone is directly seated and started writing. Okay, okay, you have a lot of experience before writing anything. Okay, if suppose if you are someone who is writing a historical book, okay, so if you want to write a historical book, okay, so you need a lot of research, right? You have to go to that particular place, you have to understand the history, you have to check with the apology departments. Okay, then also check with the other people, the older people. Then you have to also go ahead with the referential materials. Okay, a lot of reference material you have to understand. So everything you have to do, okay, before printing just a one book. Okay, so in that case, the author has to use his intellectual, okay, to write a book, to make arrangements, okay, to indexing it. Okay, so everything that he has to do is his own creation. Okay, and that own creation is nothing but your copyright, because he has come up with his own thoughts. Okay, these thoughts are never been written anywhere. Okay, not in this format, might be. Okay, so if somebody can say, "Ki, sir, like already there are books, right? The physics ka, okay, we can come to know that, okay? Ki koi bhi book, okay, any book that is already published, okay, so you may say that, "Ki, sir, the content is already similar, right?" Yeah, that I can say the content is almost similar everywhere, okay, but the font, the using thing, okay, the sequence, okay, and then your thoughts are making that is a new. Okay, so whenever somebody is copyright, protect the right of author. Okay, that is a creator of intellectual properties. Okay, the author who is creating intellectual property can be protected by the copyright law. Okay, so like he or she is also called the first owner of copyright. Okay, right, first owner, second owner. The who one is like holding it first time, called as first owner. Okay, in very simple term, कुठेही example जर घेतला आपण एक normal example जर घेतलं तर first owner, second owner, third owner. Okay, तर obviously जो सगळ्यात सुरुवातीला the one who is starting it, okay, he is the first owner of that particular thing, okay, or that particular book. Okay, it is not about only the writing a book. Okay, it is writing about anything. Okay, any your drama, it could be any other poem, okay, blogs, anything that you can do first time which is not publicly known, okay, or public is not aware with something, okay, and you are doing the very first time is nothing but your copyright. The second point here, however, in course of employment, the employer is the first owner of this rights. Okay, so if you're working for someone, okay, if suppose I am working for an Infosys, okay, and I developed something, okay, I developed one program using Infosys resources, okay, because I am working under Infosys, okay, and I use their system to design something, design any particular program. Okay, so in that case, employer is the first owner of these rights. Okay, so employer holding all the rights. Okay, the copyright things are employer holding. Okay, very simple. मी जर एखाद्या कंपनीत काम करतोय आणि मी त्या कंपनीमध्ये काहीतरी प्रोडक्ट बनवतोय, प्रोडक्ट वरती रिसर्च करतोय, ओके, अँड इफ आय मेड इट, ओके, मी काहीतरी एखादा नवीन प्रोग्राम क्रिएट केला, ओके, कंपनीने मला सांगितलं दीज आर द रिक्वायरमेंट्स, ओके, अकॉर्डिंग टू द रिक्वायरमेंट्स मी एखाद्या प्रोजेक्ट वरती काम करतोय आणि ऍट द एंड आय एम डन विथ दॅट प्रोजेक्ट. ओके, मी तो प्रोजेक्ट बनवला आणि तो जसा ऍज एक्सपेक्टेड इट इज वर्किंग ऍज एक्सपेक्टेड, राईट, जसं एक्सपेक्ट करत होतो तसं वर्क पण करतो. ओके, सो इन दॅट केस I cannot say that it is made by me, okay, because somebody has given me that idea. Okay, आणि स्पेसिफिकली कंपनीने मला ती आयडिया दिली आणि त्यांच्या आयडियानुसार मी त्याच्यावरती काम केलं. आय यूज कंपनीज रिसोर्सेस. मी काय केलं, कंपनीचेच रिसोर्स यूज केले सगळे. मी त्यांचं सिस्टम यूज केलं, मी त्यांचेच प्रोग्राम यूज केले, मी त्यांचेच बुक्स यूज केले. ओके, सो आय यूज देम सेल्फ. ओके, तर त्या केसमध्ये इन दॅट सिनॅरिओ, ओके, द ओनर ऑफ दॅट राईट इज युअर कंपनी. ओके, तुमचा एम्प्लॉयर ज्याच्याकडे तुम्ही काम करता तो त्याचा ओनर असतो. ठीक आहे, कारण की तुम्ही त्याच्यासाठी काम केलेलं आहे, त्याच्याकडे राहून त्याचे पैसेही मिळालेले आहेत तुम्हाला. ओके ओके ओके, लेट्स अगेन चेक आउट द ऑथर. ओके, सपोज एखादा ऑथर आहे आणि त्याने एखादं बुक लिहिलं, तो कुठे एका कंपनीसाठी बुक लिहित नाही. ओके, तो स्वतःसाठी बुक लिहितो आणि स्वतःच्या नावाने पब्लिश करतो. पण सेम एखादा एम्प्लॉई आहे, त्या कंपनीसाठी काम करतो आणि कंपनीसाठी काहीतरी बनवतो. ओके, आणि मग ते पुढे मार्केटमध्ये लॉन्च करतो. ओके, दॅट इज नथिंग बट युअर he is the first owner, but जे कंपनीसाठी लॉन्च केलं तर कंपनी इज द ओनर बिकॉज कंपनी हॅज गिव्हन हिम सम मनी. कंपनीने काय केलं, पैसे दिले. ओके, जसं की yesterday I said की people are like the one who is like working for a group. ओके, असाइनी ग्रुप. सपोज एखाद्या लसीवरती काम करते कोणीतरी. ओके, someone is working on the any vaccination. So in that vaccination there is a group, okay, and someone is only leading. Okay, but they all together are working for any XYZ industry. कुठल्या तरी एका XYZ इंडस्ट्री साठी ते काम करत असतात आणि मग तिथनच त्यांना काय मिळतं. सो दे गॉट टू नो दॅट the company has decided what to do, and then accordingly the company is the owner at the end. Okay, the company is the owner of that particular asset or the copyright. Okay, okay, so we have a chart. Okay, in that chart we have mentioned what is work and the creator of work. Okay, so literary or dramatic work, कुठलेही एखादं पुस्तक म्हणा, काही पण म्हणा. ओके, ऑथर असतो त्याच्यासाठी. ओके, द ऑथर इज रायटिंग. ओके, द ड्रामॅटिक इज ऑल्सो एनी ड्रामॅटिक वर्क. ओके, लाईक सपोज एनी ड्रामा, जे नाटक असतं किंवा एनी थिएटर ड्रामाज असतात, थिएटर प्ले असतात. ओके, सगळे काय असतात, एनिथिंग दॅट कॅन बी क्रिएटेड बाय अ ऑथर. ओके, द ऑथर इज द one who is holding the right. Okay, then second, musical work. Okay, the composer. Okay, might be the one, might be the two. Okay, might be the group. Like as a one is like anyone, like Himesh Reshmiya, we can say the musical work, main composer, right? If two, like I think Shekhar. Okay, yeah, I think the Ajay Atul is the one who are leading the two. Okay, there are two composer. Okay, so they are holding the same rights. Okay, also we can, if we can talk about the Shankar S. Loy, so they are the three. Okay, so they three are working together. So this is like they all three are the owner of that, or the owner of that copyright. Okay, the first owner of that copyright of the musical work, anything. Okay, then cinematographer. Okay, the producer who is producing the movie, the sound recorder. Okay, who is again the producer of the movie. So who is the creator of work? Okay, who is creating that? Okay, who is thinking in his mind? Okay, so I'll take that scene in this particular scenario. Okay, I can use this light. Okay, I can use this particular platform. Okay, I can use this background. Okay, I can use this bike or anything that they can want to use, any property that they want to use in the movie. Okay, so everything coming from their own mind. Okay, so here is nothing but something is according to the actor or anyone. Okay, so it is directly coming through their own mind. Okay, so after that something is coming through their own mind, so nothing but it's a sound recording or the cinematographer. Okay, so producer is the creator of work, and then he is the one who is the owner of the copyright in that sense. Okay, the next thing is a photography. Okay, the photographer is something. Okay, so most of the time, like some, if like people are putting the photographs, okay, on the website, so they are always using their own logo, okay, for the photographs. Okay, so why they are using their own logo? So it should tell the people that this photograph is belongs to me. Okay, and I have given that scenario. Okay, I have given that position to the person. Okay, and that is how we are using the same photograph. Okay, so they are holding it. Okay, so specifically why we are doing all this thing, because whatever the work they have done, okay, the original work. Okay, so the works are originally when they are independently created by a human author, or and the minimal degree of creativity. So in independent creation, we can say simply means that you create it yourself without copying. Okay, the Supreme Court has said that to be creative, a work must have a spark and modicum of the creativity. Okay, so there are some things, however, like that, not creativity, like a titles, name, short designs. Okay, mere variation of a typographic ornaments, lettering, okay, or coloring, and mere listening to the ingredients of the contents. Okay, so always keep in mind that copyright protect the expression and never ideas, producers, methods, systems, okay, processes and concepts, principle of discoveries. Okay, so this is basically we are talking about the whose rights are protected. Okay, so here the author's rights are protected, composer rights are protected, producer's rights are protected, and photographer's rights are protected. Okay, so this is all about your whose rights are protected. Okay, who is like the Copyright Act belongs to whom? Okay, or like whose rights Copyright Acts will be going to protect it. So these are the persons. Okay, these are the creator of work. Their right going to be protected in the near future. Okay. So why copyright? Okay, so what is the need of copyright normally? Okay, why copyright? Right, we need to understand, right, why copyright is important, because everyone is saying copyright, copyright. Okay, but why it is important? Okay, so basically there are a couple of benefits like favor and against. Okay, so why copyright? So favor thing is reward creative efforts. Okay, whatever the creative effort that I'm giving, it should be rewarded. Okay, so the next person will motivate by it, and then he also start working on a creativity. Okay, then protect interest of the creator, the one who has created something. Okay, so we need to protect his interest. Okay, so if somebody started copying him, he also loses interest. Okay, creating something. Okay, then against. Okay, so this is in favor, right? What is again? The protect the corporate interest only. Okay, if somebody, as I already said, okay, if I'm working for any XYZ organization, okay, and I have created something, okay, and I cannot say that it's mine. Okay, so that is again the company has to say that, you know, this thing is belongs to us, this copyright is belongs to us. So then criminalizing legitimate use. Okay, so somebody cannot use, okay, using their own name. Okay, so against, like if you use the same thing, okay, So people will file a complaint against you, file a suit against you, okay, and then you have to suffer a lot of changes, okay, challenges, okay, in the court, okay. So what are the basically benefits of the copyright that we have seen, the favor and against, okay? Like for example, like exclusive use of the own copyright, right? So once you get copyright for your work, okay, right, others cannot use it without your permission. That is the main thing, right? So you will get that exclusive use offer, right? So once you get copyright of your work, others cannot use it without your permission, right? It's your own, right? So if any infringement take place, you can carry out legal action. Okay. If suppose you have written any particular blog, okay, on the internet, okay, and you come to know that the second someone has already used your blog using his own credentials, saying that the blog is written by me. In that case, if you have the copyright with you, you can simply go ahead and sue against him in a court, okay, and then court will take a legal action, okay. So that is a exclusive use is also the one benefit, okay. Then record of ownership, okay. So what is mean by record of ownership? So once you get the copyright registered, okay, so there will be a public record of the ownership of your work, okay. So publicly everyone is know, okay, so you are the one who is holding the copyright, okay. So it is like basically what happens a lot of time. So you can say that just give me a second, guys. Okay, fine, no problem. Okay, so the record of ownership. So you can, like, once you get the copyrights registered, there will be a public record of the ownership of your work. So your work will be known by the public. Okay, so public is already aware that particular work belongs to you. Okay, then third thing, preventing misuse. Yeah, I already said that. Okay, so you can prevent misuse of your work by registering a copyright. Okay, so if you don't want someone should copy your thing and then misuse it, okay, for his own purpose, okay, for his own profit, okay, for his own thing, okay. So in that case, if you registered your copyright, so you can protect that thing, okay. So you will have a more control over it, how it is presented to the public, okay. So it's all your own decision, okay, when you want to publish, okay, when you want to go ahead with the public and everything, okay. So that is also the one important benefit of it. Then economic gain, yes, absolutely, economic gain is the one thing, okay. So because the most of the crucial benefit is the economy you drive from the same, okay. You will have the sole right to any revenue that accrues from your original work, okay. So whatever the original work you do, okay, if you written the books, okay, you have spent a lot of time, you have spent a lot of money, okay, to writing a book very particular. In that case, okay, you have spent a lot of money, right? So you are expecting something back out of it, right? Whenever we are investing something, we definitely checking for the return on investment, right? Always we are looking for a return on any particular investment, okay. Since I'm an author, so I also need to run my house, right? I also need to run my households, okay. So I have a family, I have everything, okay. So I need to run everything, right? Since I'm like planning or using a more time with my creativity, okay. So I also ask by the money, okay. So the economic growth or economic gain will be covered by the copyright. Then encourages creativity. Okay, how it encourages creativity? So it encourages general creativity. Society's owner enjoy the benefits of creativity work. Yeah, definitely people started thinking about it, okay. So because if somebody is creating something and earning a lot of money, so definitely my mind will say, okay, instead of doing something, can I do it, can we do it, okay. So recently we've seen a lot of web series in the internet, okay. So the specific small groups are creating their own web series, okay, and they're trying to earn money from the YouTube or everyone, okay. So that is nothing but it is encouraging your creativity, because people come to know that, okay, if we come again with a new technology or something, new creativity that is public will love, okay. So definitely it encourages the others creativity, okay? So other people also try to look forward, and then they also go ahead with the adding a new creativity in their own things, okay. So specifically the couple of benefits I would say, okay. So why copyright is important, okay. So we have seen the favor and against, and then couple of benefits. So there is again one more thing. Okay, so copyright national versus international. Okay, so what is mean by national copyright? What is mean by international copyright? Okay, so specifically, no single international copyright for whole world. Okay, so you cannot copyright something for whole world. Okay, in a single registration. Okay, why it is not single registration? Because definitely every country has a different laws, right? So copyright specifically it is depend on the country to country. Okay, so no single international copyright for a whole world. Okay, so you cannot say that ki my copyright is only acceptable by the whole world. Okay, okay. Then the second point, the Copyright Act of each country is compliant with the most international conventions and territories. Okay, so definitely again the country to country it definitely changes, right? So I cannot say like something that I have created in India. Okay, I can say that the same thing will be banned, or I can hold the copyright of the international level too. Okay, so someone also called it like if suppose they can also check out for this. Okay, so specifically, so no single international copyright for whole world. Okay, so the Copyright Act for each country is a compliant. Okay, with the most international conventions and treaties. Okay, so specifically we are helping with this. Okay, so no one can be used by this. Okay, so global copyrights and everything. Okay, so something cannot be a global copyright. Okay, and even though in any country there is no specific law. Okay, no specific law, like there is no such things as an international copyright law. Okay, so almost like we have a 180 countries have rectified treaty. Okay, but we cannot say that there is a copyright law by any of these things. Okay, so in India, the Copyright Act 1957 is compliant with this international conventions and treaties. Okay, so specifically, although we don't have any a firm law, okay, at a global level, but still every country has their own laws. Okay, so in India, we have the Copyright Act 1957. Okay, the complement with this international conventions and treaties. Okay, so Berne Convention of 1886. Okay, so this is the one when we have started. Then Universal Copyright Convention of 1951. Okay, so earlier we used to use Berne Convention of 1886. Then we come up with the Universal Copyright Convention of 1951, and then Agreement on Trade Related Aspects and Intellectual Property Rights. So again, they have again introduced the agreement on a trade intellectual aspect of a intellectual property rights, which is nothing but a TRIPS. Okay. So whenever like we are talking about any particular law, okay. So this is how the Indian Copyright Act, okay, coming into the picture, okay, at the 1957, okay, after like the 6 to 7 years from the or 10 years down line from the freedom. Okay, that the freedom we got, okay, in 1947. So we started with the Copyright Act 1957. Okay, okay, so let's have a look about the Indian Copyright Act 1957. Okay, so we just seen there is no global law. Okay, no such a global international law for any of the copyright, right? So the first right in India in 1914. Okay, so when we have started, okay, so we have started with the 1914. Okay, the first right in India in 1914 about the Copyright Act. Okay, then now Indian Copyright Act 1957 with effective from 1958. Okay, so something like we come across. Okay, there were some changes made. Okay, so what we thought we come across with the new thing. Okay, which is specifically the Indian Copyright Act 1957 was done, and then after that we have started using it, or with effective from WEF is like with effective from 1958. Okay, so we come up with the new thoughts, okay, which is on the 1957, and then government has started using this act on 1958. Okay, then further amendments in 1983, 1984, 1992, 1994, and 1999. Okay, as I already said, there were a couple of amendments that need to be happening every law. Okay, because whenever they come across with the law, okay, whenever they written the law, that time might be the all situation does not occur. Okay, so once the situation starting occurs, okay, start occurs, okay, then the people start amending it. Okay, so the amendments is basically the changes according to the situation. Okay, so whatever the new situations are arising, okay, that changes are being involved into it, okay, being amended into it, and that is nothing but your amendments. Okay, so the further amendments has happened in 1983, 1984, 1992, 1994, and 1999. Okay, the next thing is about your adopted many English provisions, introduced new ideas and concepts. Okay, so the law has adopted the couple of provisions. Okay, the provisions is nothing but your the English provisions. Okay, so anything that is done by the English law or Britishers, okay, that we have started using it. Okay, so like we don't design our own. Okay, so what we did, we used our own, okay, by the English provisions. Okay, what we did, we used the some English provisions. Okay, the way Britishers has, okay, the one like we have started using it. Okay, so introducing new ideas and concepts for it. Then created copyright office and copyright board. Okay, after doing all these things, okay, after establishing the 1957 Act, and then making a lot of amendments, they came to know that they need a copyright office and copyright board. So they have created a copyright office and copyright board. Okay. Then introduce the civil and criminal remedies against the infringement. Okay. So if there is someone, okay, infringement is already I said, okay, उल्लंघन, एखादी गोष्टीचं उल्लंघन करणं, okay, violation करणं, violate करणे एखादी policy. Okay. If somebody said ki do not share this movie on YouTube, okay, but I got the copy and I shared on YouTube, that is an infringement. Okay, infringement. Okay, that is infringement basically. बरोबर, कुणास तरी मी काय करतोय, चोरून याच्यावरती टाकतोय. Okay, so that is nothing but your infringement. Okay, so they have introduced civil and criminal remedies. Okay, then remedies is nothing but your any particular diagnosis of the diseases, and then giving the proper I would say giving you proper medication about it. That is nothing but your remedies. Okay, so remedies against infringement. Okay, so these are the basically the upchar basically happen. Okay, so these are the remedies against the infringement. Okay, so introduces civil and criminal remedies. Okay, definitely it was required. Okay, because if there is only nothing to be happen like this. Okay, so people like ever they can be always go ahead and then they start using it without a fear. Okay, so that is your introducing civil and criminal remedies against the infringement. Okay, so basically the copyright law protects expressions of ideas rather than the ideas themselves. Okay, and it protects the original works of a ownership. Also it gives an exclusive right to do or authorize others, okay, to do a certain acts in relation to the literary, dramatical, musical, and artistic work, cinematography, and sound recordings, right? Also, we have the computer programs, okay, are also included in literary works, okay. So, authors of computer programs, broadcasting organizations are to be given the right to authorize or the prohibit the commercial rental of their work to the public. So this similar exclusive rights also apply to the films. Okay. So in the Copyright Act 1957, we would say the along with the copyright rules 1958, okay, is the governing law for a copyright protection in India. Okay. After independence, the Indian Copyright Act was the first law which was entered from the provision of a Berne Convention. Okay, and the objective of this law was the encouragement of the original work. Okay, so people can encourage the original work. Okay, then the protection of originator. Okay, then they were made a couple of development in a copyright laws in India. Okay, so there are couple like it is developed in a three different phases. Okay, the act is developed in the three different phases. Okay, the first phase is the early phase. Okay, so specifically in 1911, okay, the earliest statutory law on copyright, okay, was made under the administration of the British rule. Okay, and the provision of the Berne Convention were followed during that phase. Okay, and the term of the copyright was for the lifetime of the author plus 7 years after his death, and the government could grant compulsory license to the publisher book. Okay, the registration was also made necessary in 1940. Okay, so whenever you want to publish any book, you have to make a registration out of it to get this law. Okay, then we have started with the second phase, which is a modern phase. Okay, so specifically in the Copyright Act of 1911 was again amended in 1914. Okay, and was it also called a modern copyright legislation? Okay, so for the very first time, so criminal sanction was introduced in the Act of Infringement of copyright. Okay, and the term of the copyright was fixed for 10 years from the date of the first publication. Okay, so specifically 10-year term was there. Okay, and this act remained applicable until the replaced by the Copyright Act 1957. Okay, and then in the 1957, okay, the Copyright Act 1957, okay, confirms that the copyright protection in the following two forms. Okay, right, the act was enacted after the independence of the nation from the British rule. Okay, and it was the first enactment of an intellectual property law. Okay, and it comes into force on 21st January 1958. Okay, so it was started developing in 1957, but it was enacted from the 21st or come into the force on the 21st January 1958. Okay, so major provisions of acts were adopted by the Berne Convention of the Protection of Literacy and Artistic Work 1886. Okay, so the history was like we have taken almost all the things from the 1886. Okay, and this act is amended 6 times till now to align with the rapid changes in society and provisions of intellectual treaties. Okay, example, Berne Convention, UCC, TRIPS agreement, and everything. Okay, so specifically, like definitely, according to the changes in society. Okay, so every day there is something new. Okay, something new is coming. Someone is doing something very differently. Okay, so in that case, in that scenario, I would say the people started thinking about it. Okay, and they come up with the changes. Okay, the changes in the economy with the changes in the act. Okay, so specifically, I would say there are like two things, okay, mainly that we have to look for: the economic rights and the moral rights. Okay, so specifically the primary works would be the original literary work, original dramatic work, original musical work, or original artistic work. Okay, and the secondary work would be the cinematography, films, and the sound recordings. Okay, so as we already seen that what are the economic rights, okay, in that, and what are the moral rights. Okay, so economic rights is nothing but your how economically you are helping. Okay, so economic right means the how much money I'm getting after doing that. Okay, after registering myself into this, how much money I'm getting, that is about the economic rights. Okay, and the moral rights, it's a respect in the society after publishing any book. As an author, okay, as a director, I have a different thing. Okay, or as a photographer, I have a different respect. So that are the moral rights, okay, that we have to look forward. Okay, so basically, in the Copyright Act 1957, we are going to see this economic rights and moral rights. Okay, so what are the different economic rights? Okay, what are the different economic right? Okay, just give me a second, guys. Okay, fine. So in the economic rights, okay, economics itself is telling about me something about money, right? Definitely, if somebody is all like spending a lot of time, a lot of resources, a lot of money for doing something, so definitely he should look forward for the some amount of good handsome amount of money from the market, okay, because of whatever he has done, right? So what are the specific rights of the author? Okay, all specifically the economic rights. Okay, so it is the first thing is to produce the copies or the reproduction of the work and to sell those copies, including typically electronic copies. Okay, anything that, okay, whenever I'm writing something, a book, okay, either it is a physical copy like a book, okay, hardcore book, or then either it is electronic book which is on the Kindle or anywhere, okay, which is already saved or shared, okay, on the PDF format or any electronic format, okay, that is the my right, okay, that is the right of the author, okay. Then to import or export the work, okay, so if I want to whatever import I want to, I can import, or whatever export, okay, I want to the other country, okay, I want to sell the book to the other country, so that is also the economic right, okay. So basically, the economic rights are those rights which help the author reap economic benefits. Okay, and these rights have been like recognized in one form of the other since 15th century. Okay, as per the section 14 of the Copyright Act 1957, we would say the different rights are recognized to the works considered in its nature. Okay, and the section provides that it's the exclusive right to the author or to do the authorize the doing the of the acts provided thereunder. Okay, so the important right generally recognized by all types of works under the Indian statute that attracted much judicial interpretation, including the reproduction rights of distribution, and rights of communication work to the public. Okay, so specifically there are the couple of things that we know. Okay, so to create the derivative work, okay, like for example the work that adopt the original work. Okay, so somebody who is like adopting the work, okay, like something, okay, in this way, if somebody is already the book is in English, okay, and somebody is doing a translation in Marathi, okay, so Marathi अनुवाद करतात काही लोक एखाद्या books, okay, so that is also adapting the work, okay, adapt the original work, okay, to it is called as to create a determinative work, okay, then to perform or display the work publicity, okay. So it's definitely, if I'm a good musician, okay, so I can go ahead and I can perform my talent, okay, in front of the people, okay, and I'll get money out of it, right? So if I'm a big singer, okay, so I can have a concerts in the market, okay, concerts, okay, and then through that concerts I can earn the money, okay, so that is like performing in front of the people, okay, or display the work publicity. Okay, so you can definitely, if you're writing any poem or if you're writing anything, okay, so it is absolutely for a publication only, right? Whenever you are publishing something, it is for the public use, okay, so you can just go ahead and then use it publicly, okay, so that is also the economic right under the economic right of Copyright Act 1957. Then next thing is to sell or assign these rights to others. Yeah, definitely I am the author, okay, so and I am the owner of that copyright, okay, so it's my thing, okay, so where to whom I want to sell it, okay, or to whom I want to assign these rights, okay, if like I have given someone a authority, okay, so copyright or something, okay, so it's definitely it can be it's my own responsibility, or it's my choice, okay, to whom I want to sell, okay, or to whom I want to give the permission to use my music, okay. So it is specifically to sell or design this rights to the others, and then to transmit or display by radio or video. Yeah, definitely, if I am recording a song, okay, so I can easily say that you can play that song on the radio, but for every single song, okay, whenever you are producing, you just have to pay me this 100 rupees, 200 rupees, 300 rupees, anything, that amount you have to decide, okay. So whenever they are playing, okay, they have to give you some amount, okay, or else they have to give you a lump sum amount for 3 years, 5 years, okay. So in that 3 years or 5 years of spam, or in that time, okay, you might go ahead and then check out about the you can might go ahead and check out about the money, okay. So once like you started using that money, okay, or giving that money, okay, so you can easily transmit or display by the radio or video, okay. So whenever you are sharing any videos or audios, okay, with any TV channel or radio stations, okay, so what you need to do, you need to give them a notice saying that you have to pay this much, okay, for like if you want to display or transmit my song, okay, or my video or audio. So basically these are the economic rights, okay, of the owner of the copyright holder. Okay, the one who is like holding the copyright. These are his own, basically the rights of that person. Okay, then
एक थोडी तांत्रिक अडचण असल्या कारणाने थोडा एक 5 मिनिटासाठी आपण क्लास हे करतोय. एक दोन मिनिटांनी पुन्हा आपण जो आपला सेशन आहे IPRचा राजेंद्र सरांचा ते चालू करते. ज्या कोणत्या विद्यार्थ्यांना स्टुडंट्सला काही क्वेश्चन्स असतील, क्वेरीज असतील तर ते आपल्या YouTube वरती तुम्ही कमेंट सेक्शन मध्ये तुमचं जे आहे क्वेरीज आहे ते तुम्ही त्यामध्ये.
sir, can you please make me a host? I'm not able to share my
सर तुम्ही हे या सर होस्ट कसं
Okay.
तशीच
Make
क्लिअर
me
तुम्ही
host.
करू शकता का सर?
No, I'm not able to. No, it is showing hard
Okay.
host disabled participants. You have to make me host.
Okay, yeah, just- yeah, sir, just 1 minute.
Now, oh yeah, sure. Let me know once you're done.
Yeah, just 1. सर तुम्ही एकदा स्टार्ट करा, व्हर्बली स्टार्ट करायला तुम्ही. मी मॅडमला सांगतो कसं करायचं. व्हर्बली स्टार्ट करा.
Can wait a couple of seconds and then we can start now once I'm able to share my screen. Yeah, guys, due to some technicality, due to some network issue, network fluctuation, I moved out of the meeting, but now I have rejoined since ma'am will be making me a host. So I will be in the screen sharing mode soon, very soon as I can. Okay. So like we were looking forward for the currently checking about the moral rights, right? So once we'll have a screen shared on mode, okay, so we'll explain again. Okay, so basically the moral rights, okay, so moral is nothing but your something which is related to your own upbringing. Okay, so moral is nothing but your naitik आपण जे म्हणतो ना moral values. Okay, so what is your naitik मूल्य असतात ना आपली naitik values. Okay, so that is the moral rights. Okay, what are the moral rights? So specifically right of a paternity. Okay, so paternity is nothing but your since like I'm the someone, okay, who is creating. Okay, so I can call it as my child, right? Okay, so in that scenario,
Yes, sir. You can share your screen.
okay, can I? Okay, sure, let me check, sir, just give me a second. Okay guys, I'm sharing my screen again. Yeah, I'm able to share, sir. Okay, fine. Sir, my voice and video is clear, right?
Yeah, yes, sir.
Okay, perfect. Okay, yeah, I just talked about moral rights, right? So moral rights is nothing but a right of a paternity. Okay, so the way I am like having my child, okay, so suppose I am writing something, okay, that is I can call it the child because I have spent a lot of time to do it, right? So it should be giving me the right of pattern, okay, so being a parent of something. Okay, so to claim authorship of the work and to prevent all others from the claiming authorship for his work. Okay, suppose if I write something, okay, if I write my own poem, okay, and I published without naming, okay, and somebody has taken out it and then somebody has started publishing it with by his name, okay, so in that case I can't do anything. Okay, but if I have written already there and it is under the Copyright Act, okay, so in that case I am the parent of that particular poem, okay, or in that particular work that I'm doing, okay, that authorship, okay, of the work, okay, or to prevent all others from the claiming the authorship of his work. Okay, so right of a paternity. Then second is right of integrity. Okay, this is very important thing in our personal life. Okay, so integrity is nothing but your how good are you, okay, the quality of being you honest, okay, how honest you are. Okay, the integrity is जर आपण सरळ सरळ मराठीत जर अर्थ काढला, okay, so it is a अखंडता. okay, आपण म्हणतो ना इंटिग्रिटी. okay, so it is a प्रामाणिकपणा आपला बेसिकली. okay, so fairness or faith. okay, so integrity is nothing but your right to prevent the distortion, multi-station or the other alternations of the his work, okay, or any other action in a relations to said work, okay, which would be prejudicial or his honor of a reputations. Okay, so most of the time we know that people are like trying to modify some content and trying to showcase by their name. Okay, so that is not an integrity. Okay, so that it's something the quality to be an honesty. Okay, so whenever you are coming across, okay, with something, okay, so it is a honesty. Okay, when it is a coming of the honesty. Okay, so right of integrity. Okay, so that is also the second very important moral right. Okay, so we should maintain that integrity. Okay, so whenever I'm publishing something to the market, okay, it should be very clear. Okay, should not be an ambiguity in between. Okay, so people cannot like do the prejudicial or the honor of a reputation. Okay, so definitely being an author, okay, getting an different respect in the society. Okay, so that is also the one thing about your moral rights. Then term of copyright. Okay, what is the term? Okay, term of copyright. Okay, so how many years or how many days or how many things, okay, you can copyright it, like which period. Okay, so the general rule is that copyright lasts for 60 years. Okay, see how many years you can be an author or owner of a copyright. So you will be a owner of a copyright of 60 years. Okay, so it is continued from the date of the author. Okay, might be Okay, so if you are a literary, okay, if you have written a book, okay, so you are the until the date, okay, you will be the owner, okay, because the book is written by you, okay, and nobody is claiming, okay, written by him or herself, other, okay. So since it is a date of the author, till the date of the author, okay, it is continued till the date of the author, okay. Specifically, it is last for 60 years minimum, I would say, okay, but literary, dramatical, musical, or artistic works, okay, any portrait, that any painting that you have made, okay, anything like any particular artistic thing, okay, any painting, any design that you have made, okay, so it can be long lasting until the death of author, okay, and might be after the death of author also, that belongs to his family or someone else, okay, the one who has author right, okay. So it is a form of the death of the author, okay. So literary, dramatical, musical, artistic works, all these things, okay, are being the copyrights, okay, and it could be the from the date of the author, okay, so it will be long lasting until the date of the authors, okay. Then from the date of publication, okay, okay, now like the 60 years, okay, for the cinematography, okay, then your sound recordings, your photographs, your posthumous publications, okay, work of government and international organization, okay, so they have a period of 60 years, okay. So their publication or their copyright will be long lasting until the 60 years, okay, from the date of publication, okay. Whenever they are publishing something, okay, if I'm working for any a particular IT firm, okay, so in that IT firm I created a new program, okay, so that program helping me to do my work, okay, that program helping me to minimize my workload, okay. So in that program, if I give it to the organization, and once organization has registered it, it will be with the rights will with organization for last 60 years, okay, minimum 60 years, okay. So there are two things here. The one, like for literary, dramatical, musical, and artistic work that is done by the people, okay, it is with the author or the worker, okay, the one who is like worked on it, it will with him for the almost like date of the author, and then the things, okay, that is published, okay, like for example cinematography, okay, sound, photograph, posthumous publication, or any government or international organizations work, okay, it could be start from the date of publication, okay, until the 60 years from the date, okay. So this is specifically we talked about the term of copyright, okay. Then registration of copyright, okay, how can we register, okay. So we have seen, okay, BERNE, okay, ban, okay, ban of a convention, okay. So what is mean by specifically ban of a convention, right? Okay. So specifically the Bain Convention adopted in 1886, right? And detailed with the protection of works and the right of their authors, okay. So specifically this is the founded, okay, this thing is founded, okay, in 1986, okay. And then people started recognizing that this is the efforts, okay. Bern Convention, they started understanding it, okay, when the things should be go ahead, okay, and which is the right way, okay. So Bern Convention registration is not needed, okay. If something is accepted by the Bern Convention, then your registration is not needed, okay. Then acquisition of a copyright is automatic within the creation of the book, okay. So whenever you creating something, okay, it will be acquisition, okay, the acquisition will be happen, okay, is automatic with the creation of the work, okay. So once you created something, there definitely you are writing your name, okay, behind it, and then you are saying that this is thing something published by you, or this is something which is published by someone, okay. So all this is an acquisition of the copyright is an automatic within the creation of the work, okay. Then registration as a prima facie evidence, okay. So specifically the prima facie is the first side of thing registration, okay. So whenever you are registering something, it is a prima facie, the first thing that you're doing, okay, the registration, okay. So specifically there are a couple of steps. The one is if it is an under Bern conviction, so registration is not needed itself, okay. It is if it is accepted by them, then acquisition of copyright is automatic within the creation of the work, okay. If the work is already in that falling under that category, okay, so definitely it's an acquisition of copyright. You don't need to do a lot of things there. Okay, then the registration as a prima facie evidence. Okay, so your registration is something that when you do the registration, it is a prima facie. That is the first evidence that you have. Okay, after registering something. Okay, so that is how the registration of copyright. Okay, so there are a couple of more steps as well. Okay, so specifically, like we have an office, right? The copyright office in the government of India. Okay, so you can directly go ahead and check out. Okay, so there are a couple the couple of steps are involved. Okay, if you want to register your copyrights. Okay, so specifically, like while registering. Okay, so you just need to go ahead and register it. Okay, through the using the Copyright Act 1957. Okay, so there are like couple of things. Okay, that you have to register. Okay, so basically you need to file an application along with the fee. Okay, DD or anything. Okay, post dated check you can do, then issue of diary number, you will get the diary number, then 30 days mandatory waiting for objections. If there is any objection, okay, then again it's a scrutinization by examiner has to scrutinize it. Then discrepancies. Okay, so no discrepancies, then again you will get a registration approved by the deputy registrar. Okay, and you will get, and at the end you will get a copyright of something. Okay, if there is a directly straight away is there is a objection. Okay, so again you have to sending the letter to the both parties, then reply to the both parties, you have to reply to them. Okay, then hearing them. Okay, so this is the basically the way of a copyright workflow that you have to follow. Okay, for the registration of copyright. Okay, so we have gone through it. Okay, so copyright symbol. Okay, so like we have seen a lot of time, the symbol is always there. Okay, in a lot of things. Okay, in the book or anything. Okay, like the symbol is there in the Microsoft Corporation or something. Okay, so use of the C symbol. Okay, so if you want to do something copyright. Okay, and once you applied it and then once you got the copyright, so start using this symbol. Okay, the copyright symbol. Okay, anyone who claims copyrights can use it. Okay, and the one who wanted to say this is something created by myself, I am the one who has created this. Okay, so you can use this symbol. Okay, as a copyright. Then not necessary to have a registration to use the designation. Okay, it is not important that which designation should you. Okay, it is not mandatory you have to complete this exam or you have to pass that exam or you should be in this position or that position. Okay, it doesn't matter. Okay, so anything that like not necessary to have a registration to use the designations. Okay, so any like, it is not necessary. Then highly advisable to incorporate a copyright notice. Okay, also along with this. Okay, you have seen that. Okay, it is a copyright notice for everywhere. Okay, so you cannot copy this property belongs to this person. Okay, or you cannot copy this, you cannot do the shooting or do this thing. This is under the Copyright Act, this. Okay, and it is covered under this. Okay, so we always seen that thing. Okay, so specifically if I take an example. Okay, see the copyright 2009 Microsoft Corporation, this is the example. Okay, so they have to mention this way. Okay, the copyright and then this copyright symbol and 2009 Microsoft Corporation. So whatever the things belongs to the Microsoft. Okay, any software, any network program, anything. Okay, so simply you can say that it is a copyright of the Microsoft Corporation and you cannot copy that thing. Okay, without a copy that thing without using of them. Okay, okay, just give me a second, I'm getting one call. Okay. So we have gone through the copyright symbol. Okay. So use of a symbol, see symbol anywhere. Okay. Anyone who claims the copyright can use it. Okay. Then it is not necessary to have a registration to use the designations. Okay. Then it's highly advisable to incorporate a copyright notice as well. Okay. So every time you can also incorporate the copyright notice. Okay. If like you are writing something. Okay. Then it is a example of a copyright 2009 Microsoft Corporation. This is the one example. Okay, so like we have seen in many books. Okay, the copyright notice is already there in a lot of books, right? If we can take any example, so if you like want to, you can see that. Okay, so you will see the copyright notice too. Okay, in a lot of books. Okay, you will see the copyright notice. Okay, you will see the prefix. Okay, so nobody should copy your things. Okay, right? So like for example, I have one book in my hand, and then it has written, okay, copyright at 2019 by Vishen Lakhani. Okay, so all right reserved. Okay, so notice should be like this. Okay, all right reserved, published in the United States by the Rodel Books and imprint of the Random House. Okay, a division of a Penguin Random House LLC, New York. redlabelbooks.com. Okay, so whenever you see any book, okay, so you will see the copyright notice. Okay, the copyright symbol is there, and the copyright notice is always there behind the book. Okay, not by the book. Okay, by anywhere. Okay, you can check out anything. Okay, so that is the book is already written, or like the copyright symbol is already there in the book. Okay, then assignment of a copyright. Okay, how can you assign it? Like what are the different things? Okay, so very first, the owner of the copyright may assign to any person the copyright either wholly or partially. Okay, if you want to give it to someone, okay, if you want to assign it to someone, okay, assign means I'm giving my authority to someone else. Okay, like suppose so sometime, okay, principal sir is not there in the college. Okay, so he is giving that authority to the vice principal. Okay, so vice principal can take all the decisions. Okay, on like if the person is not there. Okay, on behalf of him. Okay, it happens everywhere. Okay, sometime might be your director is not there, or sometime might be your author is not there. Okay, so in that case, someone should be there who can take the decision, right? So you cannot lose your business opportunity. Okay, so in that case, the owner of the copyright may assign to any person the copyright either wholly or partially. Either you can give it up fully, okay, or you can partially you can give it. Okay, so that is the one thing. Then duration in case of a default 5 years. Okay, so whenever like I'm giving, okay, I'm assigning that task to someone else, I'm assigning that ownership of my copyright to someone else. Okay, whether it is a partial or full, its maximum duration of that is a 5 years. Okay, the default duration is 5 years. Okay, it is a by default 5 years duration for that assignment of someone. Okay, I'm assigning it to the someone. Okay, the next thing, the moral rights are independent of the author's copyright and remains with him even after assignment of the copyright. Okay, the moral rights are independent of the author's, okay, copyright and remain with him even after assignment of the copyright. Yes, we have seen two things. The one is economic rights and another one is a moral rights. Okay, so in the economic right, specifically, I can give the economic rights. Okay, economic rights will be shared with anyone. Okay, there is no constraint for it. Okay, there is no barrier for it. Okay, so specifically, whenever I am saying it, okay, so it is absolutely given to the people. Okay, so the moral rights still reserved with the copyright holder. Okay, the one who is holding it originally. Okay, so it will never be transferable to the assignee person. Okay, so the moral rights are independent of the author's copyright and remain with him even after the assignment of the copyright. Okay, so only the in a nutshell, basically, it is only this thing is the copyrights, the economic rights will be transferred. Okay, after assigning to someone, and then moral rights with that the same person. Okay, so this is how like you should assign your copyright to the person. Okay, so three things very important. The owner of the copyright may assign to any person the copyright either wholly or partially. Okay, second, the duration in case of default 5 years, and then the moral rights are independent of the author's copyright and remain with him even assignment of the copyright. So these are the specifically, I would say, the things, okay, that we have to understand. The next thing, counterfeiting to copyright. Okay, so what is mean by the counterfeit? Okay, so counterfeiting to the copyright. Okay, the word counterfeit means, okay, what is mean by counterfeit? Okay, so counterfeiting is nothing but an exact limitation of something valuable with an intention to deceive or defraud. Okay, so it means there is any particular valuation for it, right? So counterfeit means बनावट, आपण थोडक्यात म्हणू शकतो एखादं बनावट. ओके, counterfeit to copyright. ओके, म्हणजे एखादी बनावट दुसरी बनवू शकतो ना कुणीतरी. ओके, so that is nothing but your counterfeiting. Okay, so for example, like counterfeit mark. Okay, the production of a certain brand bags by putting a false label and sold at a low prices. Yeah, definitely आपण म्हणतो ना फर्स्ट कॉपी आहे. ओके, दॅट इज अ फसवणूक. ओके, बनाव काय केलं त्यांनी, फसवणूक केली लोकांची. ओके, दॅट इज अ काउंटरफिट. ओके, सो द प्रोडक्शन ऑफ अ सर्टन ब्रँड backed by putting a false label and sold at a low prices. Okay, so that is also a mark. Okay, the trademark that I can say, the using any label. Okay, like for example Nike bag. Okay, so Nike is definitely, I would say, it's like 2000 3000 costing. Okay, but if you are taking the only the symbol, okay, Nike bag symbol, they are putting into any normal bag. Okay, and they're selling that bag into 600 or 700. Okay, so that is a counterfeit mark. Okay, the second thing, then counterfeit products. Okay, like for example copies of articles similar to the original under the different name. Okay, also we can see the duplicate copies of the books. Okay, so like if we go into any particular shop, okay, and if we ask them for original copy, so original copies cost almost 500 700 800 1200. Okay, but the same copies I'll get outside, okay, with just rupees 200 100, okay, 99, anything, any amount. Okay, so that is counterfeit product. So sometimes people started using it. Okay, sometimes people started counterfeit products. Okay, for example, like for example, you're like using the logos, okay, then using the products, okay, the similar kind of product. Okay, so if like I can go ahead with, okay, right, so the shoes, Nike shoes or Adidas shoes, okay, or any other branded shoes. Okay, so people are getting like, some people are getting in 1,000, some people are getting in hundreds. Okay, so that is also the copies of articles similar to the original under the different name. Okay, like for example, like I'm writing a book, okay, XYZ Limited, the book for the XYZ program. Okay, and someone is just writing it, the book for YXZ program. Okay, so he's just changing the some sequence and some names and having the same content and using it, okay, to the market. Okay, so that is again a copyright thing. So that is a counterfeit products. Okay, then next thing, infringement mixed. Okay, what is infringement mixed? So copy for both the model and a brand. Example, fake Louis Vuitton bags or Rolex watches of instances. Infringement mixed. Okay, infringement, I already said, उल्लंघन, एखाद्या गोष्टी उल्लंघन केलं. Okay, so कुणीतरी काय करत exactly similar copy. Okay, for example, like if we take an example of a JBL headphones. Okay, JBL headphones exactly similar kind copy आहे. Okay, copy headphone येतो. किंवा मग तुम्ही विचार करा एखादं ऍपलचं आहे, ऍपलचं स्मार्ट वॉच आहे. ओके, पीपल आर बाईंग द फर्स्ट कॉपी ऑफ स्मार्ट वॉच. इट इज अ इन्फ्रिगमेंट मिक्स. ओके, म्हणजे पूर्णच्या पूर्ण मिक्स केलं, म्हणजे प्रोडक्ट लोगो पण वापरलाय. ओके, देन त्यांनी काय केलंय, मॉडेल पण वापरलंय, आणि ब्रँड नेम पण वापरलं. ओके, so just they are making a smaller changes and they are using it. Okay, so that is an infringement mixed. Okay, because Apple is putting a lot of efforts, okay, in the technology, but someone is there who is storing the technology, okay, using the cheaper products, okay, and selling the market, okay, with a more cheaper prices than Apple. Okay, same with every product, right? आपण जर ब्रँडेड एखादी वस्तू घ्यायला गेलो तर डेफिनेटली द ब्रँडेड कॉस्ट हायर. ओके, बिट हायर, मच हायर, भरपूर पैसे लागतात एखादी ब्रँडेड वस्तू घ्यायला. पण सिमिलर वे मध्ये आपण जर गेलो मार्केटमध्ये, राईट, भरपूर कॉस्ट लागते. पण ते जर कॉस्ट कॉपीराईट वगैरे असतील तर डेफिनेटली पीपल विल नॉट कॉपी देम. ओके, और देन इफ दे सपोज कॉपी देम, देन the company files suit against them. Okay, they file the complaint against them, case against them, and they have to suffer all the legislative losses. Okay, त्यांना सगळे losses face करावं लागतील. Okay, so it is nothing but an infringement mixed. Okay, then next thing is infringement of copyright. आता बघा, आपण काय बघितलं, we have seen the counterfeit mark. Okay, then counterfeit products, and then infringement mix. Okay, now infringement of copyright. Okay, so आता copyright ला पण काही लोक चेंज करतात. For example, copying or using the work of another creator without a prior permission. For example, एखादं song आहे. Okay, आता म्युझिक इंडस्ट्री मध्ये असं भरपूर होतं. Okay, it happens a lot in music industry. Okay, if any new song, okay, any old song recreated by someone, okay, and जसं की एखादं जुनं सॉन्ग घेतलं आणि त्याला रिक्रिएट केलं. Okay, so again, if while recreating that song, okay, if somebody has taken the permission, that is fine, but sometimes they are not taking the permission, they are using the lyrics using the same different music. Okay, lyrics घेतात, different music use करतात. Okay, भरपूर सारे example, right? Okay, so it is nothing but your infringement of copyright, right? Okay, so the copying of using the work another creator without his prior permission, म्हणजे भरपूर, म्हणजे अनुप मलिक वरती पण भरपूर सारे आरोप असे झाले. Okay, he has stolen the music from the different industries, right? We know that, right, very well. Okay, किंवा मग काही गाणे बघा, एखादे जुने गाणे असतात त्याला नवीन रिक्रिएट करतात. ओके, मग कधी कधी त्याचे हे घेतात पण कधी कधी राईट्स पण घेत नाहीत. ओके, सो ऑल दिस थिंग, ओके, इट इज अ इन्फ्रिंगमेंट ऑफ अ कॉपीराईट, त्याला कॉपीराईट इन्फ्रिंगमेंट म्हणतात. किंवा मग बऱ्याच वेळेस बघा, कवितेतले काही शब्द तोडमोड करायचे आणि त्यालाच यूज करायचं. ओके, राईट. So that is how like we can say. Okay, and right now the many people are like working on this because the YouTube is very famous and people are getting a lot of money from YouTube. Okay, so people started using each one's content, each other's content. Okay, right. So most of the time like we seen that, right, people are started copying it and using it. Okay, so it is nothing a copyright issues of the copyright. Okay, so you cannot like, so as I already said, okay, people are like copying the lyrics. Okay, also copying the some tunes. Okay, also copying the style. Okay, so all these things, okay, are coming under the Copyright Act. Okay, so that is, it is an infringement of the copyright. Okay, so this is a counterfeiting to the copyright. Okay, it is nothing but a counterfeiting means banawat. Okay, so which is not exactly the original. Okay, so it is a fake. Okay, so this is all about the counterfeiting to the copyright. Okay, so counterfeiting, counterfeit marks, okay, counterfeit products, then infringement mix, and then infringement of copyright. Okay, so these are the things that we have seen in the counterfeit to the product. Okay, so next slide is about that act resulting infringement. Okay, so whenever you come across with the things, okay, तुम्हाला जेव्हा कळतं की as an author or as a creator of content, okay, तुम्हाला असं कळतं की कोणीतरी यूज केले तुमचं कंटेंट. ओके, सो इन दॅट केस, ओके, you can act, okay, resulting a infringement. Okay, you can just go ahead and into the market and just try to find out, okay, it's really happened or not. Okay, and if you come to know that it happens with you, okay, so directly go ahead and file a suits against that person. Okay, सरळ कंप्लेंट करायची त्याच्या अगेन्स्ट. ओके, so you will get that benefit. Okay, so you have that right. तो तुमचा राईट आहे की कोणीतरी तुमची क्रिएटिव्हिटी यूज करते, okay, without asking you. Okay, because that is your right. Okay, so it's very simple. Okay, then making a infringing copies for sale or hire. हा, बऱ्याच वेळेस लोक फर्स्ट कॉपी बनवतात ना बुक्सच्या. ऍज आय ऑलरेडी सेट, ओके, ओरिजिनल बुक कॉस्ट अ लॉट. ओरिजिनल बुक भरपूर महाग असतो, राईट? सो इन दॅट ओरिजिनल बुक कॉस्ट अ लॉट. ओके, सो पीपल आर लाईक मेकिंग कॉपी अँड सेलिंग इट. ओके, बाहेर मार्केटमध्ये 100 200 रुपये पुस्तक विकवतात. जे ओरिजिनल प्राइस असते पुस्तकाचे 1000 2000 3000 असतात. बिकॉज दे हॅव टू गिव्ह सम मनी टू द ऑथर ॲज वेल, राईट? ऑथरला जर पैसे द्यायचे, एक्सक्यूज मी गाइस, just give me a second. Okay, so whenever I want to give some amount to the author, right, so I have to sell it in a very increased amount. Okay, I cannot sell with the cheaper rates. Okay, I have to sell it within a higher rates. Okay, so people are like making their copies, okay, and then selling to the public. Because if I am the person, okay, and I want to read something, मला एखादं पुस्तक वाचायचं, okay, and if I'll get that book in the market with 1,000 rupees, okay, original book is costing 1,000 rupees, okay. So and then if I'll go, okay, into the market for 1,000 rupees, and in the outside market I'm getting that book, okay, मला ते book कितीत मिळतंय, suppose मला 200 रुपयात 300 रुपयात मिळते, okay. Okay, so if I'm getting that, okay, that book is, because it's more costly, okay, if I'll go to buy it more like original book, okay, so I'm getting that book 1,000 rupees, okay, and if the same book I'm getting at 400, so definitely I'll think, Arey, I just have to read it, okay, I don't need to do anything else, so why should not I go ahead and buy the same, okay. But guys, this is again lawful offense, okay, this is an offense, okay, you cannot buy that book as well, okay. As a buyer you also can be sued against you, okay, तुमच्यावरती केस होऊ शकते as a by default buyer म्हणून, कारण की तुम्ही ते infringement book तुम्ही खरेदी केले, fraud book तुम्ही खरेदी केले, okay. So making infringement copies for sale and hire, and then permitting any place where the performance constitution, okay. Right, okay, suppose if I am the singer, okay, and I'm a very great singer, but what I'm doing, I have only couple of songs, okay, माझे फक्त 2-3 songs आहेत, okay, but still I'm going out and I'm doing a big concert, मी मोठे concerts करतोय, right. So in that concert I cannot sing all the songs from the other singers too, okay. मला जर एखाद्या सिंगरचं सॉन्ग घ्यायचं असेल ना, ओके, जे की टी सिरीज न बनवलेलं असेल किंवा मग आणखी कुठल्याही मीडियानं बनवलेलं असेल, ओके. So in that case what I want to do, I just need to go ahead, okay, and I need to take a permission from them, okay, then only I'll be permitted to perform that thing, okay, perform that thing in a front, okay. You cannot use any like drama, okay, you have to like for the commercial use, okay, कुठलाही ड्रामा असू दे, कुठलाही नाटक असू दे, कमर्शियल पर्पज तुम्ही जर करत असाल ना, तर यू हॅव टू टेक अ परमिशन फ्रॉम द ऑथर. ऑथरला तुम्हाला परमिशन घ्यावं लागतं आणि ऑथर कडनं तुम्हाला काय करावं लागतं, त्याची परमिशन घेतल्यानंतर देन ओनली यू कॅन एबल टू परफॉर्म इन फ्रंट ऑफ द पब्लिक, ओके. सो दिस आर द कपल ऑफ थिंग्स दॅट वी हॅव टू अंडरस्टँड, ओके. सो ऍक्ट्स रिझल्टिंग इन्फ्रिंगमेंट, making infringing copies for the sale or hire, and then permitting any places where the performance constitutions, okay. So this is how like we have to take care of the things, okay. Then the next slide is about remedies for copyright infringement, okay. So word again, the remedies, okay. Remedies means, okay, it is a like upay, okay. So we can say treatment, okay. So nothing but in English it's a treatment for copyright infringement. जर कोणीतरी कॉपीराइट जर हे केलं, उल्लंघन केलं कॉपीराइटचं, तर त्याच्यावरती काय ट्रीटमेंट आहे, रेमेडीज ऑफ कॉपीराइट ट्रीटमेंट, ऑब्वियस आहे, राईट. म्हणजे जर कोणी जर हे केलं तुमच्या कॉपीराइटचं, तुम्ही काहीतरी हे केलं, easily you can go ahead and do the couple of things, right. जर कोणीतरी तुमचे कॉपीराइट म्हणजे कोणीतरी तुमचे बुक स्वस्तात विकतंय किंवा कमी पैशात विकतंय किंवा आणखी काहीतरी करून विकतंय, ओके. तर मग तुम्ही काय करू शकता, व्हॉट आर द थिंग्स दॅट इन युअर हँड, कुठल्या गोष्टी असतील, बरोबर ना. डेफिनेटली आय वुड डू कपल ऑफ थिंग, राईट. आय कॅनॉट सिट डाऊन, ओके, विथ आयडल, ओके. मी असंच आरामात नाही बसू शकत ना. कुणीतरी माझ्या समोर माझ्याच पुस्तकाच्या डुप्लिकेट कॉपीज विकते, राईट. कुणीतरी माझ्याच प्रोडक्टचे डुप्लिकेट कॉपीज विकते. आय कॅनॉट सिट आयडल, राईट. मी असंच नाही बसून राहू शकत ना खाली, ओके. सो व्हॉट कॅन आय डू इन दॅट केस, ओके. रेमेडीज फॉर कॉपीराइट इन्फ्रिंजमेंट, ओके. तर माझ्याकडे काय ट्रीटमेंट किंवा काय उपयोग आहेत त्याचे, ओके. सो व्हेरी फर्स्ट थिंग, व्हॉट कॅन आय डू, सो आय कॅन file a civil remedies, okay. Civil complaint, criminal complaint, and administrative, okay. These are the three things, okay. So what can I do? So there are three kinds of remedies against the infringement of the copyright book. कुठल्या three kinds of remedies आहेत? Civil आहे, civil remedies, criminal remedies, and then administrative remedies, okay. So what is meant by civil remedies? Okay, so basically the injection, damages or the account of profit delivery of infringing copy, and damages for a conversions, okay. So basically जर मला त्याच्या माझ्या सामाजिक याच्यावरती जर काही प्रॉब्लेम्स होत असतील, तर आय कॅन गो अहेड विथ दिस सिव्हिल थिंग, ओके. So I'll take the damages of a convergence. Okay, simply I'll go ahead with it. Okay, then when I file the criminal remedies, okay, so the civil remedies, injunctions, damages accounts, okay, then delivery of infringement copy, then damages for conversations. Okay, so these are the things. Okay, so the criminal remedy, what is mean by the imprisonment of the accused or imposition of the fine or both seizure of infringing copies. Okay, सर पुन्हा तर मला असं सापडलं की ज्याच्याकडे माझ्या कॉपीज सापडल्या सगळ्या, तर मी काय करू शकतो? सो इम्प्रिझनमेंट, मी त्याला जेलमध्ये पण टाकू शकतो या गोष्टींमुळे, राईट? आय कॅन पुट हिम बिहाइंड द बार्स, त्याला जेलमध्ये आपण टाकू शकतो जर असं कोणी करताना आढळलं तर. ओके, ऑर एल्स ही हॅज टू पे सम फाईन. ओके, ही हॅज टू पे सम फाईन, फाईन पण भरावं लागू शकतो किंवा दोन्ही पण असू शकतो. ओके, अकॉर्डिंग टू द ऑफेन्स. ओके, किती कुठल्या प्रकारचा हे ऑफेन्स आहे त्याच्यानुसार आपण काय करू शकतो, दोन्ही गोष्टी करू शकतो. ओके, सो आयदर आय कॅन गो हेड विथ द इम्प्रिजमेंट, ओके, ऑर आय कॅन गो हेड विथ द सिव्हिल रेमेडीज. ओके, देन ऍडमिनिस्ट्रेटिव्ह रेमेडीज. ओके, आपण थर्ड पॉइंट जो बघितला होता, ओके, दॅट इज द रेमेडीज फॉर कॉपीराइट इन्फ्रिंगमेंट. इट्स इज ऍडमिनिस्ट्रेटिव्ह. ओके, इन्फ्रिंगमेंट इज नथिंग बट युअर उल्लंघन, एखादं व्हायोलेशन ऑफ पॉलिसी. ओके, सो administrative remedies क्या असू शकते? So administrative remedies consist of moving the register of a copyright to be ban the import of infringing copies into India when the infringement is by way such a imposition of the delivery of the confiscated infringement copies of the owner of the copyright and seeking their delivery. Okay, if suppose something is published in US, okay, and then somebody started importing the things, okay, which is not the original. Okay, that is the first copy or something like that. Okay, it's a copy of that. So it is not like that ki somebody should come, okay, and then start, okay, using it. Okay, so in that case what happens most of the time, people have started using it. Okay, so in that case what can I do? I can stop that import and export. Okay, I'll ask the people to stop everything as is. Okay, and then what can I do? I'll seeking for the help. Okay, so I cannot deliver the things. Okay, those are incorrect. Okay, so it's like somebody's again fragmenting the copyright rules. Okay, so that is an administrative remedy. Okay, so these are the three remedies are there: the civil, criminal, and then administrative remedies. Okay, so specifically the jurisdiction of the courts suit or the other civil proceedings relating to the infringement of the copyright is field in the district court or the high court within whose jurisdiction the plaintiff resides, okay, or carries on a business or where the cause of action arose irrespective of the place of the residence of a place of a business or the defendant. Okay, so specifically I can either go ahead with the district court or I can go ahead with the high court. Okay, so there is no restriction about the place. Okay, so where it happens, where did he is staying, okay, where did it happen, okay, where it takes place, everything. Okay, so basically it is under the jurisdiction of every court. Okay, so basically you can directly go ahead with the district court or high court, okay, within the whose jurisdiction the plaintiff resides or a carriage of a business. Okay, जितना कुठनं ती केस झाली किंवा बिझनेस कॅरी झाला तिथे. ओके, आता थोडे लिमिटेशन्स पण आहे. देर आर कपल ऑफ लिमिटेशन्स फॉर दिस रूल ॲज वेल. ओके, व्हॉट आर द limitations? So first thing is the period of a limitation for filing the suit is 3 years from the date of infringement. जर 3 वर्षात तुम्ही इन्फ्रिंगमेंट करू शकता, असं म्हणजे तुम्हाला आता बेसिकली होऊ शकतं की तुम्हाला आयडिया नाही आली सुरुवातीला. ओके, so if you like you have published any book, okay, and then you started selling it, okay, but somebody has infringemented it, okay, somebody has copied it, okay, and started using, but at the end of the third year you came to know that, then only you can file the complaint. Okay, max to max 3 years are with you. Okay, 3 वर्षात तुम्ही काय करू शकता, कंप्लेंट फाईल करू शकता. ते समोरच्या माणसाकडे की हा माणूस काय करतोय, ही इज सेलिंग द बुक्स, ओके, विदाउट माय परमिशन, प्रायर परमिशन. त्यावेळेस आपण काय करू शकतो, पुढे जाऊन आपण कंप्लेंट करू शकतो. ओके, वी कॅन file the complaint against that the next party, okay, saying that boss, this is the person, okay, who is selling the books, okay, and this is exactly the copy of my books. Okay, so very simple manner. Okay, so in that only that like you that the criminal okay. So specifically the criminal remedies. Okay. Rishikesh sir, am I audible? Hello. Yeah, hopefully I am. Okay. So the next thing is that, guys, criminal remedies. Okay. So what are the things that can be covered? What are the definite things about it? Okay. So we're going to see this. Okay. So it's more related to the criminal remedies. Okay. So criminal offense is done knowingly. Okay. Yeah, definitely. If somebody is doing something, okay, which is not unknown, right? म्हणजे एखादं क्रिमिनल एखादं ओके ते अननोइंगली काही करत नाही ओके मना तू काय करतो चुकून होत नाही त्याच्या हात तू नोविंगली करतो ओके सो क्रिमिनल ऑफेन्स इज डन नोविंगली ओके somebody is doing something okay with the he is already aware okay so whatever I'm doing is it's absolutely wrong but still he's doing something okay that is then knowingly the thing is that knowingly okay he never does anything unknowingly okay so specifically criminal offense if done knowingly जर जाणून बुजून केलं तर ओके जर एखादं क्रिमिनल ऑफेन्स आहे ते जर जाणून बुजून केलं तर व्हॉट कॅन आय डू इन दॅट सेन्स ओके काय करू शकतो आपण द व्हेरी फर्स्ट थिंग इम्प्रिझनमेंट ओके म्हणजे जेल होऊ शकतो ओके किती तर 6 months to 3 years ओके हाऊ मेनी इयर 6 years to 3 years 6 months to 3 years किती वर्ष जेल होऊ शकतं 6 years to 3 years okay for the imprisonment then fine okay fine is like 50,000 to 2 lakh okay according to the according to the situation okay means it is not compulsory like 50,000 but like 50,000 to 2 lakh okay anything that is happen okay within that particular period okay like fine is for the 50,000 okay so along with imprisonment there is a fine as well okay for like 50,000 to anything okay according to the situation okay according to the okay according to the situation according to the this thing okay then केव्हा होऊ शकते seizure of infringing copies जर मला if I able to capture this copies म्हणजे मला जर कॉपी सापडल्यात तर जर एखादं चुकून विकतोय माझं काहीतरी ओके मी काय केलं एखादं मूवी रिलीज केलं ओके आणि तो मूवी मला कोणाच्या तरी लॅपटॉप मध्ये सापडला ओके कारण की मी तो अजून मार्केटमध्ये पब्लिश नाही केला मग त्याच्या कसा ओके इन दॅट केस इफ आय गॉट टू नो दॅट ओके मला जर सापडलं ओके तो इन दॅट केस आय विल फाइल द कंप्लेंट अँड देन गव्हर्नमेंट this action okay so government has to send him like behind the bars for 6 months to 3 months okay and then also government has to make him a fine for 5,000 50,000 to 2 lakh rupees okay very simple okay then say user of implementing copies okay so if I capture the copies okay somewhere okay let me give you an example about it right so गेम्स ऑफ थ्रोन जीओटी भरपूर लोकांनी बघितलं असेल गेम्स ऑफ थ्रोन्स ओके सो इट वॉज हॅक्ड ओके सो गेम्स ऑफ थ्रोनचा जो 7th सिरीज होती ना 7th सिरीज हॅक झाली होती ओके अँड देन दे फाउंड द पर्सन ओके दे हॅव चार्ज ऑलमोस्ट 1 billion ओके म्हणजे जवळपास 6,000 करोड रुपये फाईन लावला होता त्यांनी त्याच्यावरती ओके बिकॉज दे वर अवेअर दॅट दे विल बट स्टील बिफोर लॉन्चिंग इट द पीपल आर एबल टू सी इट ओके भरपूर मूवीच्या बाबतीत पण झालंय ओके नटसम्राट मूवी होता मागे याचा महेश मांजरेकरचा त्या मूवीज पण काय झालं की somebody has put in that movie into the YouTube okay and then they have cut the scene they have added the scenes and then again they published it. Okay, they launched. Okay, they made a premium like show and everything. Okay, so it happens. Okay, it happens easily. Okay, people are like, there are a couple of people those are like just playing around with all these things. Okay, they are always there and they are trying to make this issues. Okay, trying to get these things happen. Okay, so basically, as I said, okay, so criminal remedies. Okay, so basically, if someone is doing, okay, it is a intentionally, okay, intentionally, not intentionally, but specifically if someone is doing intentionally or knowingly, okay, if he is already aware ki if I do this, okay, मी हे जर केलं तर मला सजा होऊ शकते, मला फाईन होऊ शकतो, okay, but still if he is doing that, okay, then there is an imprisonment of 6 to 3 years and then there is a fine as well with the 50 to 2 lakh. Okay, when we got to know that, or we capture the copies in that particular machine or in that particular way. Okay, so basically all these things are there. So criminal remedies. Okay, so I'm just moving ahead with the limitations to copyright. Okay, so idea expressions. Okay, dichotomy. Okay, so what is mean by idea expression dichotomy? So itself saying that the few things, right? What are the limitations are also there, right? Okay, so it means specifically if there is any dividation of two things. Okay, add expression dichotomy. Okay, dividation of two things. Okay, the idea. Okay, dividation of two things like is the two constant or two constraint. Okay, the two contrast thing, we can say it. Dichotomy is nothing but your contrast. Okay, so if I'm saying something, the sun revolves around the earth, okay, and somebody is saying the no, earth revolves around the sun. Okay, so there are dichotomy, the contrast from the two people. Okay, so idea expression dichotomy. Okay, so might be if I would say the glass is full, okay, the glass is half, okay, and somebody say glass is half with the water and half with the air. Okay, so it's my thought process, right? How I want to see, okay, the idea expression dichotomy, because people might be come up with the new ideas. So protect only the original expression of ideas and not the ideas themselves. Okay, the way I said की मला जर एखादा ग्लास दिसला ठेवलेला एखाद्या ठिकाणी आणि तो ग्लास मी म्हटलं की हा अर्धा भरलेला आहे, एखादा म्हटलं अर्धा ग्लास खाली. ओके, इट्स अगेन डिपेंड, राइट, व्हाट माय थिंकिंग इज अबाउट. ओके, बट एक्झॅक्टली द मीनिंग एक्सप्रेशन, द ग्लास इज फिल्ड विथ हाफ वॉटर. ओके, अर्धा त्याने भरलेला, दॅट इज द ओरिजिनल आयडिया. ओके, सो आपण असं हे एक्झॅक्टली सांगू शकत नाही की त्या केसमध्ये आपण कॉपीराइट करू शकत नाही. ओके, so we can't copyright the thing in that sense because we are not sure, right? That sense, what can we do? Okay, so idea expression dichotomy. Okay, so it protects only the original expression of ideas and not the ideas themselves. Okay, त्याच्या अराउंड आयडिया नाही, फक्त जी मेन आयडिया आहे त्याची कन्सेप्ट. ओके, की वॉटर बॉइल at 100 डिग्री सेल्सियस. ओके, 100 डिग्रीला होतं. ओके, 99 ला पण वाफ येतेच ना वॉटर मधनं. ओके, 98 ला येत असेल, 97 ला येत असेल, but exact boiling point is 100 degree. Okay, so that is an idea expression dichotomy. Okay, about it. Okay, so it protects only the original expression of ideas and not the ideas themselves. Okay, the another thing is the first scale doctrine. Okay, so the second point is the first sale doctrine. Okay, so what is mean by doctrine? So it means how can I teach the person? Okay, the teaching, the way of teaching. Okay, or advisor, counselor, okay, anything that. Okay, the first scale of doctrine. Okay, so it does not restrict the owner of the coffee from reselling legitimately obtained copies of the copyright work. Okay, so absolutely, if I already selling something, okay, and if I made a more changes, okay, so it is not helping me. Okay, so like suppose I'm saying that I have only written 10 things about any particular thing. Okay, so that 10 thing is already copyright, but if I come across with more 12 things, okay, so if somebody says, okay, how to climb a mountain वरती कसं चढायचं, एखाद्याने ऑलरेडी 10 वेज दिले, 10 प्रकारे चढू शकता तुम्ही, रोप लावून चढू शकता, डायरेक्ट चढू शकता, क्लाइंबिंग करू शकता, whatever. But if somebody said ki I will directly take you to the helicopter and directly put into the peak of the any mountain or hill, okay, that is also the new thing. Okay, so that new thing you cannot stop. Okay, so that is the first scale doctrine. Okay, so for example, does not restrict the owner of a copy from the reselling the legitimately obtained copies of a copyrighted work. Okay, So it will not restrict the owner of the copy from the reselling. Okay, something is around it, like the more changes, something is coming up things. Okay, so you cannot change it. Okay, so this is the limitation of the copyright. Okay, the next thing, limitations of the copyright is again the continued thing. Okay, so fair use and fair dealing, right? We want a fair use and fair deal, right? कुणाला असं कुणा फसवलेलं नाही चालणार ना, सगळ्यांना फेअर डील हवी असते, सगळ्यांना फेअर चान्स हवा असतो एक लाईफ मध्ये, राईट? सो एव्हरीवन वॉन्ट्स अ फेअर डील. ओके, सो फेअर यूज अँड फेअर डील. ओके, सो इफ समबडी इज सेइंग की अरे मी नवीन एवढं चांगलं बुक काढलंय आणि लोक डुप्लिकेट कॉपीज घेतात, किंवा मग म्युझिक डायरेक्टर काय मी एवढं चांगलं म्युझिक काढलंय लोक डाउनलोड करतायत, ओके, कॅसेट्स घेत नाही, कॅसेट्स जमाना नाही राहिला, पण सबस्क्रिप्शन घेत नाही बेसिफिकली. ओके, किंवा मग एखादा आर्टिस्ट म्हणेल की यार मी एवढं चांगलं बुक लिहिलंय आणि लोक डुप्लिकेट कॉपीज घेतात. ओके, सो दॅट इज अगेन द फेअर यूज. ओके, दॅट इज नॉट अ फेअर यूज, राईट? म्हणजे कुणीतरी एवढं जीव तोडून एखादं काम करतंय, एखादी क्रिएटिव्हिटी करताय, आणि ते तुम्ही काय करताय की डुप्लिकेट मध्ये खरेदी करताय, कमी याच्यात स्वस्त खरेदी करताय. आपण म्हणतो ना काय करायचं, ते बाहेर जे बुक आहे तेच घेऊन ये, ओरिजिनल बुक आपण घेतच नाही बऱ्याच वेळेस. ओके, दॅट इज नॉट अ फेअर यूज अँड फेअर डील. ओके, सो लिमिटेशन इज दॅट. ओके, सो फॉर द पर्पज ऑफ रिसर्च और प्रायव्हेट स्टडी. ओके, ऑब्वियस आहे, लोक कधीतरी रिसर्च किंवा प्रायव्हेट स्टडीसाठी म्हणू शकतात की जाऊ जाऊ दे थोडे पैसे वाचवायचे, सो आय कॅन डू इट. ओके, सो दॅट इज नॉट अ फेअर यूज. ओके, सो फॉर द पर्पज ऑफ रिसर्च अँड प्रायव्हेट स्टडी, देन फॉर लर्निंग अँड टीचिंग अ क्लासरूम. येस, ऍब्सोल्युटली. आता जे लर्निंग अँड क्लासरूम, सपोज आता मी एवढं हे बनवलं, एवढी पीपीटी बनवली, मी आता ही थोडीच कॉपीराइट करणार आहे. ओके, सो इट इज फॉर द पर्पज ऑफ लर्निंग अँड टीचिंग इन अ क्लासरूम, राईट? फॉर क्रिटिसिझम ऑर ओव्हरव्ह्यू. आता एखाद्या मूवीवरती मी क्रिटिसाइज केलं, ओके, माझे क्रिटिसिझमचे पॉईंट टाकले, ओके, किंवा मी माझा ओव्हरव्ह्यू दिला की ओव्हरऑल मूवी कशी आहे, काय असेल पाहिजे, काय नसेल पाहिजे. सो इन दॅट केस आय कॅनॉट कॉपीराइट दॅट कंटेंट, राईट? मी का कॉपीराइट करणार ना, एवढा वेळ नाही ना माझ्याकडे. Okay, so I cannot go ahead and copyright that thing, right? So these are the couple of things, right? The next thing is that for reporting current events. Okay, yeah, if I'm reporting something currently, okay, so I cannot go ahead and do the copyright. Okay, that is also a limitation. Okay, I can't wait for the people to do all this thing, right? Okay, the next thing is for connection with judicial proceedings. Okay, then performing the non-paying audience. Okay, then other specific condition. Yeah, right, performing the non-paying audience means sometime if like I'm performing but people are not paying for me, they are not paying any money. Okay, so in that case also I can say that there's a limitations. Okay, so the fair use of fair dealing. Okay, so you should be, these are the limitations. Okay, the fair use and fair dealing limitations, like for the purpose of the researcher of the private study, then for learning and teaching in classroom, then for criticism or overview, for recording current events, okay, in connection with judicial proceedings, performance and non-paying audience, and then all the specific conditions. Okay, so I can't go ahead with all these things and then I can't do this. Okay, so basically I have to take care of all these things. Okay, so these are the fair use and fair dealings. Okay, 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 then some government works are exempted in India. Okay, if suppose act a legislature, if suppose I'm writing something about legislative writing. Okay, so legislature is nothing but your specifically I would say it is more related to your lawful. Okay, okay, so basically it is more about the legislature. Okay, means एक कायदेविषयक, ठीक है. Okay, so in that case, like some government works are exempted in India. Okay, so act of legislature. Okay, so whenever like I'm rectifying any rules or regulations, okay, so I can't do this, right? Then report of a committee, commission, council, okay, board or other body appointed by the government. Okay, whenever they are coming with any new report, okay, government भरपूर याचे committee बसवतो. Okay, like for example irrigation committee असते government ची, for example any any committees are there, okay, who is like doing a lot of things for government, okay, that cannot be copyright. Your metros a project, okay, you can't copyright those things, okay, because that project is something which is like a report of committee, commission, council, board of others, like body appointed by the government, okay, you cannot do the copyright of those things, okay. The next thing is that judgment or the order of a court, tribunal, or the other judicial authority. So whenever the court is giving something, okay, so in that case you cannot mark them as a copyright, okay, so you cannot say that is a copyright for, okay. So these are the couple of things about the limitation of a copyright, okay. So the first in act of a legislature, then report of a committee, commission, council, board, and other like body appointed by the government, judgment or the order of a court, okay, tribunal or the other judicial authority, okay. So this cannot be a copyright, okay. So we have to make sure that, okay, this should not be a copyright, okay. Okay, fine. And then moving ahead with the next slide, okay, so we are at the end of the sessions, okay. So basically this is the summary, okay. After that we'll again going to see a couple of more examples about it, okay. So summary itself, each country has own law compliant to the international convention, okay. So every country has their own law, okay. So you cannot say that Indian thing will be accepted in the US, okay. So every country has the different law for it, okay, for the copyright purpose. Okay, then copyright prevents distribution of idea, not idea itself. Okay, distribution of idea. Okay, how I'm distributing that idea. Okay, and the idea is remains same. Okay, so there might be chances. Okay, the people can use the same idea with the different logic. Okay, so we know that a lot of people are like drawing some, taking a picture of moon, right? So moon is always there, right? The idea is same. Taking of a moon, the picture of moon is always same. Okay, but the angle, the used camera, the used lens, and everything is different, right? The day they have taken the picture, it's a different, right? So it means the copyright is nothing but prevent a distribution of idea, okay, not the idea itself. Okay, it prevent the distribution. Okay, so nobody can distribute it. If suppose it's on my name, okay, so it's mine only, okay. So not idea itself. Then it safeguards interest of the creator. Definitely, it helping to save the creator's interest. Okay, because if I'm a creator and I'm introducing something into the market, so absolutely it's my right, okay, to make those changes, okay, or to use that, okay. So in that case, I would directly say that, okay, boss, it's mine, okay, the product is belongs to mine, okay, I'm doing this, okay, I'm the one who is holding the rights. So it safeguard my interest, okay, it is helping me to save my interest, okay. So no one can move ahead and then use it, okay. So safeguard interest to the creators. The next thing, it encourages people to create something new. Definitely, as I already we have seen that, okay. So if suppose I am a good author, okay, and I got a great publicity, okay, people have started knowing me, okay. So the others authors also started thinking in that sense, and they also started working on those things, okay. So it encourages the other people to also create something very different, right? So we have a lot of competitions, right? The photography competitions are there, okay. A lot of the wildlife photography is there, then the astrological photography is there, okay. So most of the time they're giving the awards, rewards, and then publishing their work, okay, then giving them a copyrights, okay. So people started thinking that why should not I, okay. So people also started, and the people will being an encouragers, and then they started working on it. Like for example, in your college also, like if any particular student come up with a particular painting, okay, and he thought ki, this painting has never been in, okay, or never been done before, so that student might be go for an copyright, and then if he gets some copyright, okay, so in that sense the other people's also intended to do so, okay, because they are also thinking, okay, so if he can, okay, so why not we are, okay. So it is again, it's an a soft pushing, okay, about the encouragement, okay. It is giving a motivation to the others, okay, to create something new. Then registration is not compulsory, so it is not mandatory to register, okay. So you can just mark it a copy, and then whenever you get time, then you can mark it a registration, okay? So it is not important to register every time everywhere, okay. once you register something, it is fine, acceptable, okay, by the people. Then economic rights can be assigned to the another person. Yeah, already seen. Okay, the economic rights only can be assigned. Okay, the moral rights cannot be. Okay, there are two rights definitely you are getting. Okay, being a copywriter. Okay, being owner of copywriter. Okay, so one is the your first thing which is assigned to the another person, and then another one is the your moral rights. Okay, the economic rights always can be shared. Okay, it can be shared by the another person. It can be used by the another person, another person. Okay, but you cannot use the moral rights of anyone. Okay, the moral rights always with the main owner of the any this owner of the copyright, right? The third thing, infringement is a criminal offense if done knowingly. If somebody is doing the infringements, okay, so definitely that person is, yeah, absolutely, the person is getting that, right, affection, right? If someone is doing that offensively, okay, so they should be okay using all these things. Okay, so if somebody has done the things knowingly, okay, so definitely I would say the people will get a, if it is considered as a criminal offense, and then we capture the copies of it, okay, in the particular system or anywhere. Okay, so definitely I would suggest, or I would go and said that uh, okay, so there is an imprisonment, there is a fine, okay, and might be the both. Okay, so this is the specifically the summary of the copyright, and this is how we are at end of the session. Okay, so these are the couple of case studies. Okay, so I will remain keep this case study, okay, 5 minutes there. Okay, and after 5 minutes I'll discuss everything, and then I'll move ahead with the next. Okay, so 5 minutes is there for your reading purpose. Okay, so I'll be back at 2:37. Okay, so till the time I want everyone to read this case study as is, and then accordingly we'll discuss, okay, after 5 minutes. Okay, fine. Okay, so I hope you have gone through this case study. Okay, so I would read it now. Okay, so specifically in this case, okay, the appellant in this matter included the director and the authors involved in the making the film Murder. Okay, so basically it is against the Ram Gopal Verma with the Premulla Amruta. Okay, so who is the respondent? Okay, who is the one who is filed the case against Ram Gopal. Okay, Ram Gopal Verma. Okay, so specifically, so the matter included the director of the others involved in the making of the film Murder. Okay, so it is all about the murder film. Okay, the respondent in this matter had a claim that, okay, what she has said, the film is allegedly based entirely on her life story. Okay, so basically the film she thought, okay, that it's based on her own story. Okay, with regard her husband dates. Okay, earlier this year, the Telangana High Court set aside an injunction from the trial court, and we had halted the release of the film Murder. Okay, so basically she has said that, okay, the story is on her. Okay, the story is her story. Okay, त्या महिलेची स्टोरी असं तिचं म्हणणं होतं. ओके, की जे काही घडले त्याचं मर्डर, तिच्या हसबंडचं मर्डर वगैरे त्यांनी घडवलं. आणि मग कोर्टाने काय केलं की कोर्टाने त्याच्यासाठी हे केलं, त्याच्यावरती बॅन केलं. ओके, so when the promo for the film was released on YouTube, okay, the respondent filed the suit against the appellants, okay, of the perpetual injunction restraining the release of the film. आणि ते काय केलं की ते फिल्म रिलीज होऊ नये म्हणून कोर्टाकडनं आदेश घेतला की कोर्टाने मनाई करावी त्या फिल्म रिलीज होण्यापासून. ओके, the lawsuit is a respondent claimed on her right to privacy guaranteed by Article 21 of the Constitution of India had been violated specifically because of the appellant's reference of her name, her husband's name, and her father's name in various social media posts while announcing the release of the film. Okay, so specifically त्यांनी काय केलं की त्या महिलेचं नावावरतीच खपवलं सगळं, की तिचं नाव दाखवलं, तिच्या फादरचं नाव दाखवलं, तिच्या हसबंडचं नाव दाखवलं. डेफिनेटली कोणाचं तरी आपण जी प्रायव्हसी असते ती आपण भंग नाही करू शकत ना. So that is what the case is all about. Okay, so after referring another honor killing in August 2020, the court stated that the events which had occurred in the life of the respondent are not unique to her or her family alone. Okay. Okay. While summarizing the principle of the protecting of the right of to privacy, the court clarified that while there was a definite right to the privacy, the exception of the principle was that once matter become a matter of public record, the right to the privacy is no longer substituting the become the legitimate subject of the committee to press the media among the others. Okay. सो जेव्हा याच्यानंतर पण अशी एखादी केस घडली आणि कोर्टाला काय वाटलं की एकटीचीच केस नाही, म्हणजे भरपूर याच्यात जोपर्यंत तुम्ही नाव वगैरे डिस्क्लोज करत नाही कुठल्याही केसमध्ये, तर नाव वगैरे जोपर्यंत तुम्ही डिस्क्लोज करत नाही त्यावेळेस काय होतं की तुम्ही हे नाही करू शकत. ओके, टिल द टाइम यू कॅनॉट से की हा प्रॉब्लेम आहे. ओके, किंवा मग ही केस सगळ्यांसाठीच लागू होते. ओके, सो दिस इज द ऑल अबाउट अ केस. ओके, आणि जर रात्र राहिली गोष्ट कसली तर तुमच्या याची प्रायव्हसीची, त्या प्रायव्हसीचं त्यांनी काय केलं बेसिकली की ती प्रायव्हसी कशी काय, ओके, त्याच्याबद्दल ते चौकशी करत. ओके, सो in the final decision given by the court, the final decision काय दिलं, the appellant were allowed to release the film after being instructed by the court that they were not allowed to use the name of the respondent and her family members. Simple term मध्ये. तर त्याने काय सांगितलं थोडक्यात की तुम्ही जर हे केलं यूज करताय ना, तर यू कॅन सिम्पली गो हेड अँड डू वन थिंग. व्हॉट कॅन यू डू, की त्याचे नाव यूज करू नका कुठल्या रिस्पॉन्डंटचे, म्हणजे ज्याने केस केली त्यांची नाव कुठे नसेल पाहिजे. ऑब्वियस आहे, नाव आपण कशी कोणाची यूज करू शकतो, ऍज इज नाही यूज करू शकत, राईट. सो दॅट इज व्हॉट थॉट इज अबाउट. ओके, सो दे हॅव इन्स्ट्रक्टेड, कोर्ट हॅज इन्स्ट्रक्टेड, ओके, ॲपिलेंट म्हणजे यांना कोर्टने काय केलं की ॲपिलेंट जे होते राम गोपाल वर्मा किंवा जे डायरेक्टर बॉडी होती त्यांना काय केलं, इन्स्ट्रक्ट केलं की तुम्ही असं नाव कोणाची यूज करू शकत नाही तुमच्या फिल्म मध्ये, ऑर एल्स तुम्ही फिल्म रिलीज करू शकता बट यू हॅव टू रिमूव्ह दोज नेम्स. ओके, सो यू कांट यूज दोज नेम्स ॲज इज. Okay, then the court also directed the appellants to publish the disclaimers showing that film was not a work of fiction. आणि कोर्टाने असंही त्यांना एक आदेश दिला की तुम्ही काय करा की असं मेन्शन करा की ही फिल्म पूर्णपणे काल्पनिक आहे. ओके, फिक्शन, एक स्टोरीवर आधारित. ओके, ही कुठली ओरिजिनल स्टोरी नाही कोणाची. सो दिस इज हाऊ द केस इज अबाउट द कॉपीराइट. ओके, सो ते म्हणजे वाटलं होतं की दॅट माइट बी द थिंग. ओके, बिकॉज हर स्टोरी, बिकॉज दॅट इज अ कॉपीराइट ऑफ इट. Okay, this is the one story about it. Okay, the next story is about the Disney Enterprises and Corporation and Ours versus Kim Carton 2 and Ours Delhi High Court. Okay, so this is again the case. Okay, you can go through it. Okay, again I'll explain what is all about the case. Okay. Okay, fine. Okay, so specifically this case is regarding the Disney Enterprises Incorporation and Kim Carton and then Delhi High Court. Okay, so it is handed over to the Delhi High Court. Okay, so basically the plaintiffs, okay, the one who is holding the rights, okay, in this matter were companies incorporated in the United States of America involved in the business of creation, production, and distribution of motion pictures and cinematography films. Okay, so we know that Disney is everywhere, right? The defendants in this lawsuit indeed several rough websites that had provided users with the free access to pirated content. Okay, so this particular website, okay, Kim Carton website is like given the access to the, look at the pirated. We know the pirated software is okay, so it is nothing but your pirated one, the copy of it, right? So the Department of Telecommunication (DOT) and the Ministry of Electronics and Information Technology (MITI), okay, were also included as a co-defendants by the plaintiffs. Okay, so they are also co-defendant because if somebody is stealing something, okay, so definitely it's the government has to also take care of it, right? We're also including the co-defendants and plaintiffs, okay, along with the several ISPs, okay, internet service providers, okay. The plaintiffs filed a lawsuit against the defendants of streaming original and copyrighted content created by the plaintiffs, okay, without acquiring any prior authorization from the plaintiffs, okay. So they have started using their content, okay. They have started sharing their content, okay. So specifically, it is like somewhere the people have started pushing out it, right, and they're publishing the content, okay, without any prior authorization from the one who is originally made it. Okay, so after reviewing the list of the infringing websites submitted by the plaintiffs, okay, and the content by being the made available on those websites. Okay, and as I already said, the content should be made, it should be captured. Okay, it should be counterfeited there. Okay, as on those websites, the court opinion that excuse me, the defendants were infringing the plaintiff's copyright. Okay, the court therefore restrained the defendants from the hosting, streaming, reproducing, distributing, making available to the public, and the communicating to the public. Okay? So court has said that you have to stop everything right now, okay, or facilitating the same their website through the internet in any manner whatsoever, any cinematograph, work, content, program, and show which is a plaintiff's own copyright. Okay, so they can stop everything right now. Okay, so whatever they have to streaming, reproducing, distributing, okay, making available to the public, okay, they have to stop everything that has created by the plaintiffs. Okay, it's nothing but the copywriter. Okay, so further the court granted an interim injunction to the favor of the plaintiffs in order to ensure that the original content created by the plaintiffs was protected, and directed the plaintiffs to file the necessary application before the court in case of any further infringement by this website. Okay, the court also ordered the DOT and MIT to issue necessary direction notification various IPs in general to block access of the defendant's website. So whatever the website those are showing them, okay, without this, okay. So simply in that term, okay, so they have started like ask them to stop everything to complete this. Okay. And next, it's about the hot cookers, okay, and then magic cook appliances. Okay, so this is the one which is like very famous in 2008. Okay, so basically the Hawkins, we know the Hawkins is a cooker brand. Okay, so Hawkins Cooker Limited, the famous Indian brand, okay, sued Magic Cook Appliances for LFly using their renowned pressure cooker line registered under the Copyright Act 1957. So they have registered their label, okay, the logo, copyright, okay, but the Magic Cook Appliances has used the same. Okay, the defendants were also deferred from using the plaintiff's cookbooks, okay, and were ordered to deliver up the petitioner company of the damage of alleged product, books, and the article employed by the defendants in the manufacturing of the offending goods. Okay, the plaintiff is also eligible to claim the damage incurred by the defendants due to the rendition of the accounts. Okay, so basically, definitely the Hawkins is the best cooker brand, right? And they're using their book, okay, the instruction manual, okay, they are using their logo, okay, and then they sold out the cookers in the market. Okay, the Magic Cook Appliances sold everything into the market. Okay, so after that they come to know that Hawkins come to know that Hawkinsला समजलं की यांनी अप्लायन्स विकलंय आणि क्वालिटी तशी नाहीये, जशी पाहिजे तशी. ओके, जर तशी पाहिजे तशी क्वालिटी नाहीये तर काय करणार मग त्या केसमध्ये? मग त्यांनी त्याच्या अगेन्स्ट केस फाईल केली आणि मग त्याच्या बदल्यात त्यांना काय मिळालं की क्लेम डॅमेजेस, जेवढे की डॅमेज त्यांच्यामुळे झाले, त्यांच्या ब्रँडला झाले, त्यांच्या नावाला झाले. ओके, तर या सगळ्या डॅमेजेसच्या बदल्यात त्यांनी काय आलं, किती पैसे, किती डॅमेजेस वगैरे हे सगळ्यांचं हे केलं त्यांनी, राईट? So this is how we are at the end of the session. So whatever the questions that you have, you can share with your teachers. Okay, share with the Rishikesh sir, and then he will giving me that questions. Okay, so sir, I'm end with my session right now for the day.
Okay. आवाज येतो सर माझा?
हो, येतो सर.
पुणे जिल्हा शिक्षण मंडळाचे बापूरावजी घोलप महाविद्यालय यांच्या अंतर्गत TY BComच्या विद्यार्थ्यांसाठी आपल्याकडे जो इंटेलेक्च्युअल प्रॉपर्टी राईट्स लॉ याचा जो आपल्याकडे सेशन चालू आहे त्याचा तिसरा दिवस आहे. तर राजेंद्र सरांनी आतापर्यंत आपल्याला जे जे इंटेलेक्च्युअल प्रॉपर्टी राईट्स बद्दल आपल्याला सांगितलेलं आहे, द इंडियन पेटंट ऍक्ट आहे, त्याची हिस्ट्री काय आहे, त्याचे पर्पजेस काय काय आहेत, टाईप्स काय काय आहेत पेटेंटचे, त्याच्यानंतर टर्म्स काय काय आहे पेटेंटच्या, नंतर पुन्हा पब्लिकेशन्स काय कोणकोणचे आहेत हे त्यांनी सांगितलं. त्याच्यानंतर त्यांनी आपल्याला सांगितलेलं आहे की स्टेजेस कोणकोणचे आहेत, की त्यांचे आपण कोणत्या फिलिंग करतो ग्रँटसाठी पेटेंटचं ते पण त्यांनी सांगितलं आहे. त्याच्यानंतर पॅरामीटर्स ऑफ पेटंट आहे, ते पण त्यांनी खूप चांगल्या पद्धतीने आणि चांगल्या सखोल माहिती आपल्याला दिलेली आहे. सोबतच त्याच्यानंतर सरांनी आपल्याला जे सांगितलेलं आहे की राईट्स, कॉपीराईट्स काय काय आहे, त्याचे मोरल राईट्स कोणते आहे, टर्म्स कोणकोणत्या आहेत कॉपीराईटच्या, रजिस्ट्रेशन कशा प्रकारे केलं जाते कॉपीराईटचं, असाइनमेंट कोणकोणत्या आहेत कॉपीराईटच्या, या सर्वाबद्दल आजच्या सेशनमध्ये सरांनी पूर्ण आपल्याला माहिती सांगितलेली आहे. कारण आपला जो सेशन आहे आजचा 12 वाजता चालू झालेला होता आणि आता 2 वाजून 52 मिनिटं झालेली आहे. तरी आतापर्यंत सरांनी खूप चांगल्या पद्धतीने पॉवर पॉईंट प्रेझेंटेशननी वेगवेगळ्या स्लाइड्स आहे, वेगवेगळे प्रेझेंटेशन्स आहे, त्यामध्ये केस स्टडीज आहे. केस स्टडीजबद्दल सरांना आपल्याला माहिती सांगितलेली आहे. या सर्व माहिती आमचे जे वाणिज्य विभागाचे जे मुलं आहेत तृतीय वर्षाचे, त्यांच्यासाठी खूप खूप महत्त्वाची माहिती सरांनी आतापर्यंत आपल्याला दिलेली आहे. भविष्यामध्ये पण या सर्व माहितीचा नक्कीच ते वापर करतील सर. आणि आपण आपल्याला एवढा अमूल्य वेळ देऊन आम्हाला एवढी सगळी माहिती पेटंट राईट्सबद्दल, कॉपीराईटबद्दल आम्हाला सांगितली, त्याबद्दल मी तुमचे मनापासून खूप खूप आभार मानतो. सोबतच मी आपल्या कार्यक्रमाची ज्यांनी सुरुवात केली, कॉर्डिनेटर ज्या आहेत आपल्या मनीषा त्रिंबके मॅडम, यांचेही मी मनापासून आभार मानतो की त्यांनी राजेंद्र सरांबद्दल जे आपल्याला पहिले माहिती दिली की राजेंद्र सर इन्फोसिस कंपनीमध्ये आहात, तिथे ते सिनियर मॅनेजर वगैरे हे सगळी माहिती मनीषा यांनी दिली, त्याबद्दल त्यांचे खूप खूप आभार मानतो. सोबतच शॉर्ट टर्म कोर्सचे जे कॉर्डिनेटर आहेत डॉक्टर एन एस गिरी सरांचेही मी आभार मानतो. त्यानंतर वाणिज्य विभागाच्या विभाग प्रमुख डॉक्टर यांचेही मी आभार मानतो. मनापासून सगळ्यात जास्त मानायचे झाले आपल्या महाविद्यालयाचे प्राचार्य नितीन सर यांचे मी आभार मानेन की त्यांनी ती चांगली संधी मुलासाठी दिली आहे. युवरती लाईव्ह आहे, वरती आपला हा पूर्ण चालतोय. त्यामुळे तृतीय वाणिज्य विभागाचे विद्यार्थी लाईव्ह सेशनही अटेंड करतात. त्यानंतर त्यांना काही पुन्हा अभ्यास करायचा, स्टडी करायचा असेल तर ते पुन्हा युट्यूब व्हिडिओ बघू शकतात. खूप आभार. आपल्या टेक्निकल साठी आपल्याला ज्या मॅडम आहेत मॅडम खूप आभार मानतो की त्यांनी आज नाही त्यांनी आपल्याला सपोर्ट केलेला आहे. टेक्निकल खूप आभार मानतो. आणि सगळ्यात शेवटी आपल्या यूट्यूबवरती सगळं सेशन त्यांनी अटेंड केलेलं आहे, त्यांची मी कार्यक्रम आहे याची सांगता करतो. धन्यवाद. राजेंद्र सर आणि सेशन एंड करायचा. राजेंद्र सर.
या शुअर थँक्यू सर.
या आणि तुम्ही क्लोज करून टाका सर, लिंक क्लोज करा. Yes.
हॅलो.
हा झालंय मॅडम.